me make a small announcement due to some unavoidable reason and for better management of the program. There is a small change in the serial of the classes to be taken today. You all have your timetables available with you. Please check it. The first session was supposed to be taken by Dr. Professor Kavita Singh. Now, Dr. Singh will be taking the second and third session of the day. The first and last session of the day will be taken by Dr. P. Paul Ramesh, Assistant Director, CFSL Kolkata. Sir is very much present here. So with this small change, we will proceed further. I request all the prosecutors who have joined through virtual mode to kindly correct the timetable for the day. The first class and the last class of the day will be taken by Dr. P. Paul Ramesh. These will be on forensic aspects of the three new laws. And the second and third classes of the day will be taken by Dr. Kavita Singh. That will be on Bharatiya Nyaya Sanhita and the relevance of new crimes introduced as a means to address the compensatory challenges and punishment schemes under the BNS. Let us start with the technical session. And before that, it will be my privilege to formally welcome Dr. P. Paul Ramesh, Assistant Director, Central Forensic Science Laboratory, Kolkata. Sir has the expertise of dealing with various matters. I was just discussing with him. Though he belongs to the basic field of physics and psychology, but he has the departmental training and vast experience of handling different matters in different sections of the CFSL. Sir, I welcome you to Odisha Judicial Academy for this 2 days training for capacity building of our prosecutors. It will be my pleasure to invite Sasmita Naik, Assistant Public Prosecutor, Court of JMFC Tirtol, to kindly felicitate. Just a minute. Babu, take help full order करने से बाहर थी जल्दी. Till we continue our formality, let me make another announcement. We are supposed to get feedbacks from you, right? Regarding the 2 days training program, we invite all of you to share your feedbacks with us, both in physical mode. I will arrange the submission of feedbacks through physical mode as well as through our Google form. And I will also request all the respected prosecutors who have joined through virtual mode to kindly also send their feedbacks to us to the Google form that we will be sending through the office of the Honorable DPP, Director of Public Prosecution, Odisha. So I request you to please send us our feedbacks, because that will help us improve our program manifold. Now I request Ms. Naik to felicitate Dr. Ramesh. Thank you, ma'am. With these words, I now request Dr. Ramesh to kindly start the deliberation on the subject, forensic evidence in new criminal laws. As all of you are aware, forensic has a very important role to play in investigation of cases, and starting from the very cardinal principle of mutual exchange by Locard, the law has taken a whole new form now, and forensic law and forensic techniques have become the forte, not only for the investigators, but also for the prosecutors and adjudicators like us. So it will be our great privilege to hear from one of the best experts that we have here. Sir, I welcome you and I request you to start your discussions. It was both. Okay.
Hello. Good morning to everybody. Nandan sir and my dear colleagues from CDTI and participants who are coming from London PPs who are coming from different courts of Orissa. It is my privilege to give a talk. I didn't say that yesterday. I remembered that 500 years experience. This is the new terminology I heard yesterday. So I repeat to you. That means we need to work together with 500 years experience. It is not the only 25 years experience fellow only need to talk. So it is always my lecture goes in an interaction mode. And anytime you are most welcome to stop me and ask any question. Okay. It is no issue in it. And who are attending in the online also, I am welcoming and I am giving my heartiest thanks to this organization as well as Orissa Judicial Academy as well as prosecution wing. Listeners, you are the pillars to establish the things in the court. So it is my privilege to have a talk. So we will go to talk now. I am discussing about two different things. One is Bharatiya Nagarika Suraksha Samiti and BSA. Both I will discuss one after the other. And what are the things my presentation goes in these two topics, specifically which is related to evidence, digital field, and forensic science. Three topics only. I selected classes I will take and discuss. Okay. So this is the first we will go to BNSS 2.1a. What is audio video electronics? What is the definition it has been given? Reason is it is the thing, it is specifically in the new act has been brought into that, specific attention has been given. There are a number of changes are there, but in the aspect of the one aspect of the change is that audio video electronics. Audio electronic means shall include use of any communication device for the purpose of video conferencing, video process of identification, search and seizure of evidence, transmission of electronic communication for such other purpose and by such other means as state government may rule provide. Means in this one, it is clearly says that means it is the power of the state, how to modalities has to implement. Okay, state will take care about it, but those rules will form in that one. But it is in this NIAM, it says clearly that means you need to follow audio video, encourage and implement these audio video applications in different modes. It may be you are using for the communication, or you are using for the evidence purpose, or maybe you are using for the summon sending, anything you are using. Audio video electronics mechanism has to be incorporated in the process. We are using so far in the mostly in the hard copy method, but we need to shift. That is the scenario it is specifically mentioned in this NIAM. And second one is BNS 2.1.1. It is specifically electronic communication. Yeah, and also it is one more point. It is specified that means where you need to encourage the communication mode also in the electronic form. Now we need to shift our scenario, our way of approach, way of thinking, way of mode of working. We need to shift ourselves. So we need to change our gear. Simply it is change of gear only. Okay, in this one, electronic communication means the communication of any written, verbal, pictorial information of video content transmitted or transferred, whether from one person to another, or from one device to another form, or from person to device, or from device to person by any means. It is person to device or device to device. Anything it or person to person also. By means of electronic device, including telephone. So they have mentioned all the modes. It may be telephonic mode, it may be mobile phone, or other wireless telecom. Yesterday we have a discussion that means it need to be internet complaint only. It is not that internet only has to use the complaint. You can make a complaint with the phone also. So that is clearly says including telephone. It is a communication only. You are using the communication method, whatever the method you may be used. So furtherly, you may be telephonic, our mobile phone or our wireless telecommunication device or the computer or a video player or camera or any electronic device or electronic form may be specified by notification by the central government. So central government will also frame what is means what method has to be followed for which things. So it is the according to that they will change the notifications also, which can be added, which can be deleted. Reason is it is a technology day. Today we are earlier used to use the pen drive, floppy drives. Now we are using the pen drives. Now tomorrow we are using strips. Someday it may come chip method. So the technology, what terminology will change in the electronic mode every year drastically. For that, they notify the names of those things day to day according to the change. That is, they wanted to mention it. What? And BNS 54, I am so speaking, identification of person arrested. So here it is also mentioned that means already you know that means all those things it is mentioned, it is provided the person identify the person arrested mentally or physically disabled, such person identification shall be taken place under the supervision of magistrate. That is already it is there. But in this one, it is the wherever you are doing, those things has to be audio, video, electronic mode recording has to be done. That is the specific extra it has been compelled on the system. So this thing has to be followed. Okay. And BNSS 63 forms of summons. So it is already, we are routinely using the manpower for the sake of sending the summons to the by personally, the wastes of transport and the manpower resources. Now we are shifting everyone we are doing in the WhatsApp telephonic mode or electronic mode. So why can't we, our courts also can shift and save the time and energy and resources of the things. So we need to shift it. In this one, this section also has included every summons issued by the court under this samhita shall be everywhere we are doing all those things. In this one, they told that in an encrypted or any other form of electronic communication shall bear the image of the seal of the court or the digital signature. So this is the things we have to. Tomorrow, every court may get the digital signature. I will talk later on in the afternoon or wherever the appropriate time comes, what is digital signature and electronic signature. So now we will go not to go into shift into our basic work. So there are terminology you may be remember, noted down what is mean by encrypted, what is mean by digital signature. So these things we will discuss later on also. Okay. In this one, it says that means in an encrypted or another form of electronic communication or shall bear the image of the seal of the court or the digital signature. Those things can be, summons can be made it and served to the people. That means it is not that means it is WhatsApp only. It is WhatsApp mein communication kar diya. It is not that means there should be it should mention that means it is a document of the court only. So that identity has to be registered in that one. So how to maintain that? They will make the modalities later on. So that has to be generated by the state government. How to electronic document we are sending to any person, how we can fix that means that is the generated by the court itself only, not by someone else. Okay, that authenticity has to be maintained. So that we have to work out the modalities by the state government. Okay. Forms of summons on the government servant. It is one more class. It has been said that whether a person summoned in the active service, reason is it is forensic people also remain summoned. So I stressed on that purpose, this point also. Reason is whether a person summoned in the active service or the government or court issuing summons shall orderly sent in the duplicate to the head of the office. It is not the summons you need to send whenever you are sending the individual person of the government capacity working person. You need to summon that person only, but the copy has to send to the head of that organization. Reason is he is working under the administration control of that person. The bondage will be lies on the head of the department, not on the individual person. So further, he is working as a government employee. So further, without his relieving, if there is a dispute between the court and the head of the department, I should allow, I should not allow. You need to do this job or a court job. So that dispute need to avoid. Furtherly, this has been brought. Whenever you are calling the government employee, so fix the person of the head of the department, not the individual person. Anyway, he is summoned, he is supposed to come, but he need to take a permission. Then again, it is a dispute between the head of the department and the summoned person. So furtherly, in this, it has been brought. BNS 68, whenever
if such person is employed, such a health should thereafter cause the summons to be served in the manner provided by the section 64 and shall return to the court under the signature of the undersigned required by that section. So whenever the evidence is the evidence, summons will be given to the person, but the one forwarding letter will be there that will be communicated to the head of the department. Such signature shall be evidence of due services. Okay. So furtherly, one more problem we are coming across is that is a real problem. Furtherly, we are sharing as a PPs. We are our real savers in the court for us. Okay. Furtherly, we are communicating that only summons will be issued. That summons won't be served to the person. Then they will mention that means 3 summons has been issued. The person has been not turned out. So give the warrant. If it is okay, warrant, it is okay. We will run and come. But you give the worst warrant. So again, it is okay, later on it won't happen, but it is a harassment to the person. He is not doing any personal work. He is doing his government job only. Furtherly, without verifying that person really served someone or not. Intentionally someone misleading the government court, it is okay. You need to go through the problem. But if the person is not the normally defense people in the court, they will manage, they don't serve the summon, and later on they will say that means the witness is not turning up, he is experts, they always make a nonsense, so give the warrant or arrest warrant. So to avoid that situation, they have brought it. So you need to maintain the signature of the witness also in the court of law. That means he is not attended on that one. He received, still he is not attended. Okay. BLSS 105, recording of search and seizure. Yesterday also we maybe thoroughly discussed about this one. The process of conducting search of the place of taking possession of any property, article, things under this chapter, under section 185, including preparation of the list of all the things is in the course. Such search and seizure and signature of such a list of witnesses shall be recorded through any audio, video, electronic means, preferably mobile phone, and police official without delay forwarding such recording to district magistrate. That is the one extra. The 2 bondages has been increased on the investigating officer. Earlier there is no, that is not there. One, whatever the process you are doing, you no need to mention, you may mention it in the case record or not, but at least you need to record in the audio video through. So that means what it is you are proceeding to done. So those things are in authentic and you did a right job. So to get the clarification to the court, to understand the court, that means the IO has been done a significantly accurate work he has carried out. To clarify that, that is one more benefit to the court and to the public. And it is another way, we are always, there is so many cases, there is a allegation that means IO not done a right job, IO not done a process properly. So to eliminate that defame from the investigating agency also, both way it serves the purpose. Okay. Second one is the whatever he did, that has to be without delay forward such recording to district magistrate. So in this one, 2 clauses are there. The administration has to take a call now here. If you wanted to implement these 2 things, you need to train the police authority, police people, how to make a record all those things. Make it okay. If they don't know how to, and they have to maintain. Yesterday also, this need how to maintain. It may be an evidence, not an evidential value. Still, it is need to be believed. Tomorrow, I have supplied one seizure list. The subject say that means who is the victim say that means no sir, that room has been not recorded, but the property has been seized and taken away by them. They have gone to one room, seizing the property of any person, and the property dispute and ED gone, and they have searched the house. 2-3 rooms they have recorded and maintained, and 1 room they have not recorded, and they have submitted. The recording will be there. That property what they have taken, it is not disclosed anywhere. So such obligations will be there. So further to avoid that means what need to be done, how it need to be proceeding has to be modalities, work rules and regulations has to be framed by the state government, how to overcome these difficulties. Then another thing is that, okay, if the record it is a digital evidence, anyone can manipulate very easily. Now, the evidence, whatever it is recorded, it is a true. Who will certify? That is one more issue. Okay, oral witnesses, though you are not believing, but if it is a digital evidence, tomorrow same allegation may come on the investigating agency. That means whatever you are recorded, it is not the true evidence. So furtherly, how to make the modalities for that? How to maintain keep the integrity, how to see that integrity in the court of law, how to verify the integrity of that one. It has been not manipulated. So in the afternoon session, I will discuss about that. I'm not going to technical matter now. In the afternoon, we will discuss thoroughly and note down and raise those questions. Okay, my request is that raise how much you pay points you raise that much you can get more information from me. Okay. BNSS 173 information in the cognizable cases. So I request that you note down that question. When the point raises, you raise that question. When I talk about it, that digital electronics information, I will discuss. If I am not going to cover in the topic, then I will clearly say that means in this one is the integrity of the question, integrity of the, and it is the evidence. Really, it is the evidence or not? The question is that it is not an evidence. It is an evidence. No, it is not an evidence. It is only procedure. It is true or not? The procedure need to be, there is no evidential value for the procedure. First thing is, I got it. Evidential has different notation and procedure have different notation. Now it is a procedure. Now it is not that means the IO is not supposed. Procedure, whatever he is doing, he has to give it. If he done the procedure, he has to mention, he has to sign. If his Caesar list is mentioned in the bottom, he will sign it. It is true or not? So it is the procedure. First, you need to understand evidence, he should not record it. But if it is a procedure, he has to maintain himself only. He has to give the certificate. Understood the difference, I think. When if it is a procedure, you have to maintain. How to maintain that? You may be heard about, okay, when you are not able to remember, then only you remember that is hash value, how to generate the hash value. Okay, in the electronic mode, whatever the material has been generated, on the generation, it is decided by hash value. Okay, we are always integrity, how we will maintain that means, one, if a investigating officer has been generated one video file, on that video file, he has to generate the hash value also. Okay, once he generates the hash value, then he pass on that generated hash value to me or the expert. The same hash value has to be reflected in me also, if I calculate. And if after my report, it goes to the court, public prosecutor may see that. When he wanted, public prosecutor also wanted to check the hash value. If he checks also, the same thing has to come. Okay, then afterwards in the trial time, judge wanted to see. At that time also hash value has to come. If in this process, everywhere the hash value is the same, that means this integrity is the same. Hash value is nothing but a seal of that. But exactly it is not that means. But the hash value is significant. If any dot of the one pixel value also has been changed in that one data, then hash value changes. But which one has to generate a hash value? That I will modalities in the afternoon I will explain. Okay, you are satisfied with the answers?
Sir, we must know that how the hash value is
I
generated.
am here for the
Unless and until we will be, sir.
afternoon section, I will make it train also to generate hash value. Okay,
Yes.
don't worry. Okay, I am here to do that job only. Then we will go to BNS 105. Then we will go to BNS 173, information cognizable cases. This is also yesterday some dispute issues are there. Every information related to commission of cognizable offences, irrespective of the area where the offence is committed, may given an oral or electronic communications officer in charge of the police station, if he given. Orally, it shall be reviewed in writing by him or under this direction and be read over to be the informer, and every such information, whether given in a written or reduced or written or other set, shall be signed by the person given it. By electronic communication shall be taken on record by him by the sign within 3 days by the person given it and option. It is electronic communication mentioned. It is not internet communication. It says clearly electronic communication. Okay, you remember that. I already given there what is the electronic communication definition. Okay. And a substance thereof shall be entered in the book to be kept, and such officer in such a form in the state government may the rules prescribed in the law. One thing you have to remember that it is not the internet communication. It is electronic communication. Already I decided what is electronic communication. It may be a phone, it may be a mobile, or it may be a CD, or anything is sent as a complaint. Reason is why I say that means yesterday we are always have a last by birth we are following the same pattern. We are not trying to shift our game. We are in one gear only traveling. We don't try to be normal human tendency. Gear change hona nahi chahiye. That is the spirit we always carry. But the things won't work out. The demand of the public changes. The demand of the public is that, one example I will say, one old family, earlier it is not that this society is so positive. Now it is not, the society is changing. Though one example I give, one family, one old lady and wife and husband are living in one house in the remote village. They get attacked by someone. Why? They will go to police station and give the complaint. Do you expect that? Should I, my parents in such an age, when they go something gone wrong, I need to meet them. Should they go to police station to give a complaint? Do you agree? We are a citizen. No. As a kid, I don't agree. My system should not work like that. My system should be work favor to the public. So matter only, they give the communication by telephone also. Now the modalities how to generate, we need to work out. The code, police station go to that person can be brought to the police station, that worked out within 3 days. That is the spirit we have to keep in mind. How to friendly to the society. How to make friendly to the society. It's in that one we have to make a rules. Okay. That is the intention is that one it has been brought into this section means 3 days leverage period to make the volatility. Reason is they need immediate action to serve to be. They can't come and police station and make a complaint. Now the technology has changed. Everything is available within the hand. Okay, one female lady here, she is in remote areas. She is suffering with some attack by male. So how she can immediately go. Maybe sometimes his mental condition may not be allowed her to go to police station and male dominated police station and put a signature. She need to go to medical immediately attend the hospital. At that time, it is a leverage period has been given to that. Okay, if it is such a cases, the police station can go to this person. The modality has to generate by the state government. Police station can go to the complainant and get the signature of that person. Or he can take the, if the information is true, the criminal crime has crime is there, he can register as a sumoto. So there is methodology, but we should not eradicate completely user-friendly apps. Okay, so we are changing the apps to make that user-friendly. Okay, right? The AC is working or not? People are not comfortable. I am also not comfortable.
The topic is hot.
The topic is hard. I agree that. Then we will go to BNS 170, the information in the cognizable case, information in the cognizable cases. So provided further that in the event that person against whom the offense that is already discovered, temporarily, permanently, mentally, physically disabled person, it needs to be audio video recording has to be carried out. Then we will go to BNSS 176. procedure for investigation. This is also one of the issues need to be discussed thoroughly. Reason is it has been changed something. It is provided further in the relation to the, in 176. Provided further in the relation of the offense of the rape, recording of statement of victim shall be conducted in the residence of the victim or in the place of her choice, and as far as practicable by a woman police officer in the presence of her parents or guardian or near relative or social worker of the locality, and statement also will be recorded through audio, video, electronic media, including mobile phone. So that is why whenever you are recording the statement, so that is they have given so many options. It may be a police officer, it may be social worker, or it may be a guardian or relatives. In their presence only, you need to record the statement. Okay, that is we have to keep in mind. And various one-sided procedure for investigation. And the receipt of any information related to commission of offense, which is made punishable for 7 years or more, the officer in charge of the police station shall form from such a date as may be notified within a period of 5 years. May state government disregard all the forensic expert to visit the crime scene to collect the forensic evidence. In the absence of such case, the videographic process may be mobile phone, may be other electronic devices. In this one also, it is one more clause has been interpreted. Some words are missing in this one. Complete act is not written in this statement. But still, in this one is the 7 years punishment. Wherever the 7 years, I should also maybe a concept discussed about this. 7 years, more than 7 years punishment. It is there. So they need to go with the forensic team. So there also one more burden has been kept on the investigating officer for the sake of the true investigation purpose. This is not to hamper by the, there is a much number of judgments. It is there that the investigating officer is not done the job properly. But it is not that when he is done or not, that's a different issue. Now we are changing the act, so we can at least to eradicate that limitations of him. Okay, wherever you may be chance to do errors, so that errors maybe we can eliminate by in the act. So in that act also rather to make when you don't need to miss reasons, the day-to-day the changes are changing, the oral witnesses are falling down drastically. Now we are getting only circumstantial evidences are coming more. So furthermore, we need to change our mode of working. For that, it is given that 5 years period has been, reason is now the system is not ready. Immediately act has been brought, but system is not ready. Furthermore, for that 5 years period has been given to state governments. That means you within that 5 years, you enhance your state of facilities. So for the 5 years, but in that one also they have given one more clause in that one. So I think it is not written. So okay, I will discuss that one also later. And in that one they have mentioned the forensic expert have to go together. Okay, it has to. He cannot go to scene of crime alone itself only. He has to go along with the scene of crime. That the team has to be made it available to him whenever the crime happens. So those are all proceedings have to be recorded by the videography. By the that only. There is one more thing. In this class, one more. That is only 5. So maybe some state government by seeing the 5 years duration is there. Okay, we will be relaxed. That is not the case. They have given one more clause for them. So if the provider the police facility is not available in respect of such offences, the state government shall until facilities in respect of matter developed are made in the state notify the utilization of such facility of any other state. ये नहीं है अगर 5 साल तक में नहीं करेंगे उसके लिए एक्सपर्ट को नहीं भेजेंगे भेजना तो है but you can utilize the where the surrounding में facilities are available you need to avail the facilities. That is the clause. There has been bondage has been kept on the state government also. Means you cannot relax 5 years. You need to take the support of the central or the state, other state facilities. BNSS 180 examination of witness by police. Any police officer making investigation under this chapter or any police officer not below the rank of state government may or by general or special order fiscal will be have acting the position of the officer may be examined. That's all those things knows isn't it? Whenever you have that process, there is nothing changed, but it is only one provide the statement and the subsection is also recorded by the audio, video, electronic means. Whenever the statements are recorded. So further now all the investigating officer has to acquaint with the audio video recording facilities and how to frame that. Means later on he will ask some questions immediately. Later on, whatever he wanted investigating, he will write this statement. So it is not that case. Now everything will be recorded. What the statement has been given by the witnesses or maybe accused, maybe victim. So those are all those things are will be in the digital mode available. So it is a one more benefit to the court also. They cannot retract with their statements that much easily. This is once it is recorded in the way. This is when it is written, okay, it can be changed. But when it is recorded, so it is very difficult for them. It is a guilty conscience will be present on them. Already one statement I have given, how I can change the statement? It may fall, it is a court matter, the court may see seriously. So furtherly, they always have the bondage on them, that means to stick to that statement.
That is the word may.
No, it is not mandate. That one, who will do? Who will do?
Sir, what you have told regarding certain figure 105. It is the word shall. Here it is may.
That one I don't know.
So it is not obligatory on the part of you to record.
No, I am not telling that means. But who will do? Who don't do? Can you guess? No, may is given, that is only mechanism is not ready. Furtherly, they have mentioned the may. Furtherly, it is every time, if it is a bondage is done, that day onward they have to follow. The mechanism is not there. So how you can implement? So furtherly, somewhere you have. That's what I'm saying. May, why they have given that this mechanism is not there. The shall says that, then they have to implement immediately. It may not be possible. The system is not ready. People are not ready. How many constables are ASS are capable enough to record audio, video recording? How many people can generate hash values? How many people can extract the videos from the mobiles? Really, our manpower is competent enough to do that job. It is now. It is may incorporated. Next amendment, it may change to shall. That is the provision. It is immediately we cannot put the bondage on our people only. But if who follows, that is my right spirit. You take consider in this one. I am not going to negative spirit. I am trying to imbibe the positive spirit in the system. Who follows, who do the right job properly, will okay. What is wrong in it? Record everything. Who wanted to do harassment? That fellow okay and leave it here unnecessarily. Why break our head? Okay, which one you promote? You promote the good practice or the bad practice? No, we are. That is what I'm telling. They have given, okay, who wanted to save their skin properly, tomorrow allegations come, it saves him. I have not done anything wrong. Okay, if he follows, may use, but he may, in the may you use that, it saves him only. I hope. Tomorrow no one can allege. I did all videography, everything properly. You can go through. My proceedings are not wrong. Okay, that way it saves and make the good practice. That is all. Yeah, I am not telling that my bondage is there. Okay, shall only it is a bondage. It is only, but still it is a cross check to him. BNSS 183.6a, recording of confession and statement. Provide also that the person making the statement temporarily or permanently, mentally or physically disabled. The statement made by the person in the absence of interpreted or special educated shall be recorded. Here it is shall. Means the reason is it is must and should. Reason is the interpreter may wrongly interpret it. Subject may not able to communicate what he wanted to communicate or he wanted to communicate. Those cases, recording may help. Tomorrow, the same thing can be interpreted by some other expert. Listen, it is not the true words. It is sign words. The sign words may you may interpret some way, that person may interpret some other way. So interpretation may change. It is the true, not the true reflection. It is coming. Other than it shall have been mentioned in this one. Search by the police officer. Police officer proceeding under subsection 1 shall be, if practical, conduct the search in person, provided the such conduct under section shall be recorded through audio video means by preferably mobile phone. The search has been given compulsion. It is a need to be, you need to follow that. Then we will go to BLSS 209, receipt of evidence from outside India. So this is one more extra class has been brought in. Reason is that the earlier we are getting whatever the evidences from other countries. We are globalized world, so we are living in a small village, and we are talking about the global world. So in the global world, we are very nearer due to electronic communication. So any crime can happen from any country. So furthermore, now we are investigating through worldwide. So worldwide investigation means we are getting the electronic communication mode of information only. So we don't get the physical modes very rarely. So furthermore, we need to follow this electronic mode also. In that way, they have to follow that. Is what this session is. And it is now we are going to forensic science specifically. BNSS 328 evidence of the officers of the mint. So whenever you are getting the reports from the stamp paper or bond papers and the currency, coins, these are all need to be examined. So who has to examine? So furthermore, this comes under 328 whenever they have given the power, that means whenever you want security. It may in this one there are number of people have been incorporated. One is the mint note printing press of any security printing press, any forensic department or forensic division of forensic science laboratory, or the government examiner question document, or state question examiner document, or the central government will be notified specified in the of the any matter things will be submitted examination of those things. So this instance Savita that has been power to given the power to those people to examine those samples. And BNSS 329 recording of scientific expert, which is normally you utilize the expert's opinion. So in this one, this section appeals to it may be a central government scientific expert, or it may be chemical examiner, assistant chemical examiner, chief control of explosives, directorate of fingerprint bureau, and directorate of Institute of Bombay, deputy director, assistant director, all central forensic science laboratories and state forensic science laboratory. The serology of the government, either the scientific expert, prescribed, certified, and notified by the state government or the central government for this purpose. Okay. These are the people who are already you know that there is no much change with us. In this BNSS 336 evidence of public servants. This is one more thing happening. Whether any document or report prepared by the public servant, scientific expert, or medical officer purpose to be used as evidence, any inquiry, trial, or other procedure such public servant expert officer either transferred, retired, or died, or public servant expert officer cannot be found incapable of giving the decision. This is the problems normally the expert case. They noticed in last 60 years, 70 years. Such presence of public servant expert officer likely to cause delay of holding the inquiry, trial, or other proceedings. In such cases, they have given us some exemptions. So the court shall be secure presence of the successor officer who followed him, who can identify his signature, who worked along with him, who associated working in that case. So those people can be called and get the evidence from that. Deposition can be done from that person. And provided that no public servant, scientific expert, or medical officer shall be copied before the court unless the report of such public servant, scientific expert, or medical expert is disputed as parties of trial or other proceedings. Provided further that deposition of such successor public servant expert or may be allowed through the audio video. So you can promote the audio video. Again, here that means it is not to sell. That means it is you need to promote. Reason is we need to reduce expenditure, man hours, and all those things. If you wanted to reduce, we need to promote video conferencing expert witnesses. And BNSS 349 specimen collection. Here also one thing you have to notice. The magistrate of first class is satisfied by the process of investigation proceeding under Samhita is expedient and direct any person, including the accused person, gives specimen signature or fingerprint impression. But I didn't get the question. Expert or officer either transferred, retired or died. I won't बोला. Expert, right? There is given public servant also. Public servant also given. So how you will interpret it that how court will interpret that I don't know exactly. I am not a legal expert. So that but the word has been like we can be IOS can take excuse of that one. But normally IO case we handled very thoroughly. So
Document. IO input, na? Sir, IO will be included in this.
But I have a doubt. IO is an evidence. IO witness is an evidence. IO witness is an evidence. It is a collaborative evidence. It is an evidence only. So finally, if it is how the things will go into that one, I don't know exactly how system will. No, that is true. If it is died, then you will stop the case. No, I want to have the person. Okay, if it transferred or not okay. If it dies, IO dies. So what you will I'm asking first we interpret the death, then we will follow to others. What is your opinion after death? How you will do? If IO expires before the trial. Successor IO will follow. But actually when you transfer that also can be followed. That is why I also did this. That is why I am also telling the same thing only. There are three people are there. Okay. When you are applying the rule, this person, the same rule you can apply to these two. That is my question. And you can apply this rule to this one. Why can't you can apply this rule to that one? If it is applicable to this rule, then you can apply that one also. Okay. If you are not able to get that person, you can apply. That is what I mean. So that is distinctly from the court to decide. Okay. So we go to next one. That is successor. It is already mentioned. Same police station person who are the deal that same case, then it happened. In that case, what the rule applicable, other case person you can apply. That is my logic. I go by my logic only. Okay. I am not a legal expert. Okay, again I say. So BLS 349 specimen collection. If a minister as first class is satisfied that for the purpose of any investigation or proceeding under Samhita, it is expedient of direct any person, including an accused person, to give specimen signature or fingerprint impression or handwriting or voice sample. It may take an order to that effect in case the person whom order related shall be present shall attend the time of place suspect or such. Okay. But here one thing has been missed. Can anyone can guess?
Yeah.
What is that?
Where should that be arrested?
Four things are mentioned. One is fingerprint, handwriting, voice, signature. One person it is one important point which has missed. Anyone can a public prosecutor can say. How will fix the person? Accused को कैसे fix करते हैं? Biometrics में चार biometrics मतलब बोल दिया और एक biometrics क्या हो सकता है? DNA. DNA तो नहीं लेते हैं, हम blood लेते हैं. So blood has been not mentioned. So it has some other notation, but only for the blood has been not incorporated in the also. Okay, keep in mind that one. So it is not comes under the shell. It comes under only discrete power of the IO, not the magistrate. So remaining all those things, court has to give a permission and subject has to go through. Okay, but reason is it is not. These are all non-invasive. That is a invasive. And one thing is invasive, and it is the blood. It can be collected anywhere available. It is truly out of probability. So vertically that has comes under some other texture, but then they are not incorporated. Here is 530 trial and proceedings. All trials, reference and proceedings under Samhita, including initial service or execution of summons or warrant. So that is again I say this, all you people need to change your gear. By all overall this summary you need to follow. If you go through this act, very clearly says that all trials, inquiries, proceedings and Samhita, including issuance, service and execution of summons and warrant, examination of complaint and witnesses, recording of evidence in inquiries and trial and appellant proceedings or other proceedings may held in electronic mode by electronic communication use of audio video electronic means. That is, it is indirectly government is requesting you people change the game. Okay. That is, I told that the government is requesting. They are not ordering you. They are requesting you. Change your gear. Change your gear. Change your mode of working. Try to reduce the government expenditure. One thing and time also. Both you can save it. So, particularly, you need to shift to our mode of working. So now we will go to. So still it is there, no? Time is there. Then we will go to next one, Bharatiya Shah Abhinayam 202. So it is a digital forensic related issue we will discuss again here. PSA 2(1)B definition. This is the basic change has been brought to you. Okay. The definition itself has been changed. Now you have given more power through this one. Document. What is meant by document? So already all definitions are there. In this one, electronic and digital record has been added as a document. Okay, that you need to know that the definition itself is changed. So that means all those things have been changed. So wherever you will go, so that means it is maybe all written documents and all you people know very well. I don't need to mention. But for final one, I wanted to say that the electronic record and email, server log, document, or computers, laptop, smartphone, messages, websites, location evidence, voicemail, message tools, digital evidence, all documents. The spectrum has been changed drastically. So you will get plenty of information to you. So, but only you need to bother about how to maintain the integrity of that one. Only as an investigating officer, you need to bother about. As a public prosecutor, you need to see that means by you are bringing from the volatile sub material, you show me the integrity at that one also. As a public prosecutor, it is your duty to, before placing before the court, you need to check the integrity of that material. Isn't it? Is any document also, if it is Xerox copy, you will check the original where it is there. So similarly, here the digital copy brought it to you, then you need to verify its integrity. That is only you need to take a precaution. Wherever the investigating officer brought the digital information, check the integrity. And definition of evidence also has been changed. So evidence definition also been drastically changed. The evidence already you know that means which is the legally admissible in the system, all those things. But final thing is all the documents, including electronic or digital records produced for the inspection of the court or such documents are called documentary evidence. Electronic evidence also called as a documentary evidence. Okay, that is the basic change. It has been brought into this section. And BSA 30, relevance of the statements in maps and charts and plans. Now, when we incorporate the digital mode, our spectrum has been changed drastically. It gone enormous of our amount. The documentary evidence is not available very easily, but electronic information will be available plenty. It is true. You agree or not? Now, if such a plenty normal statement, conventional part of isolated document. Now it is a electronic evidence is there. I will also say that this whatever electronic material comes, it will all come and throw you. If I wanted to know that this one person bank account, he may be worked in different 4-10 banks. He did a fraud. Maybe in India, he may have 100 branches, he has done a fraud. Can any 100 branches data can be studied and can be analyzed by the court? It is possible. Not possible. At that time only, when if someone who analyzes all those data and gives the output to you as an opinion, that can be easily accessed by the court. So you don't need to court. If I give an example, if I used to do CCTV footage, one building में crime हुआ ना, building का पूरा CCTV निकाल के लेके आपको दे दिया, बस जेल साहब देखो आप पूरा बोलेगा तो होगा, it won't be possible, and that is not going to be done. That is the word here mentioned. The document information, how to make it relevant only. Now you assign jobs to someone expert, he will collect and analyze it, and which is relevant to the case, that much he will collect it and make a presentation to the court. Then that can be worked out as his opinion, and it can be considered and make it as a document. Suddenly, in such a cases, these things have been part of that. Now the electronic documentation is there. The court should not linger on for each evidence to verify all those things. Now you can assign those works to some other expert, and all analysis and outcome can be taken into view, and he can analyze that outcome, and when he wanted, he can go back to smaller things, whatever he have done, he can, the patches can be analyzed and it can be made a good bill. So that is the specificity in this one has been mentioned.
Enter day footage is there. Suppose the time of incident and that particular fact is technical evidence by live. So the entire video recording has a common aspect. The entire has the root to be 37, and that is taken from that has the root. So if you definitely give me different has the root. So how can it be improved that divide from the original as well?
The hash value will change. If I remove one hair from my body, it is not my body. It is my body or not? My body only. So it is a part of the body. You are right. So how to prove this? That is the only issue. So now that hash value is this, that is the holistic files. Holistic file. If I take one hour away from that part, that hash value same won't become. It will generate different hash value. who collected that separate document from that original document. And that was the earlier IT Act mentioned 65B certificate. In this one more clause is brought in that I will disclose. Later on I will come to that. So whoever may be doing the job, but I got the point what I said. It is CCT footage is there, DVR. It is complete hash value. I am extracting complete first. That is one. That is total hash value. Out of that total hash value, I am taking only one file out of it. Maybe 100 files are there, maybe 100 lines is there. I am taking only one segment of that. Then automatically, if I take some segment, it is a copy of that one. But that copy is not the same hash value it will come. It is clear. Change is taking place, but it has to be conducted by the expert person only. When it is extracting from the thing. Okay. We got it. Now that also person expert means who is expert? It is not the expert means forensic expert only.
So sir, how that part connected good two parts. Fractional part and the original part. Connected one. Then the fractional part cannot be not be developed unless the prosecution measures that proves that this part is part of the original.
That's why I got it. That is the expert will say how to do it. I will explain it. I will come to that part when I come to. I will explain. And when you go to BSS 39(1), opinion of third person when relevant. So there is also in this one also one more drastic change has been brought in. Earlier, when the opinion of things, it is only science word is there. But now they have brought the art word. Science or art. So specifically the formulas and science and the art. So this is one any person can, any expert can give the opinion in this one act. Opinion of the third person. So, but in this one also opinion of third person is discreetly power to accept or not. Okay. Without any. Identify handwriting, fingerprint, opinion of persons, physical stain, any other field, questions, identify handwriting. No, it is part by only. See?
Same.
You go to 39(2). Opinion of third person related to electronic information when relevant. So, I am requesting now you people to, sorry, public prosecutors from July 1st onwards, any case registered FIR, those cases, any electronic information brought in that one, any electronic expert opinion is there, then that person needs to be registered under section 79A. Then only you can win the case on that basis. If it is not there, then your case you will fail, that evidence will be go as a null. Later on, don't blame, no one told me us. The judge's defense lawyer will take lead, strong defense. Reason is clearly stated that expert need to be under 79A. Section IT Act 79A, if you go through, then you will know that this what is 79A means it is special body for giving expert opinion on electronic material. Electronic material opinion. That person needs to be registered under the 79A. For the IT Act only, but now for any electronic evidence, that one also it is not followed so far, but now it is in Samhita, so that only need to be followed.
Opinion. Whenever opinion is there, then section 79A will happen.
I will say that opinion only I told. That person only I told. Not the evidence. That person need to be under 79A registered. I didn't say that all electronic evidences. Okay. When you are making any opinion about electronic evidence, that person opinion need to be considered in the court of law. then it will be considered, then it is 79A. Okay, so you need to compel the state government also to make their own liabilities to be registered under 79A. Okay. BSA 40 facts bearing upon opinion of experts. Facts otherwise relevant are relevant if they support or inconsistent with the opinion of experts, and such opinions are relevant. Okay, now again the question is that these experts have given some leverage. The defense lawyer always asks the question, yes or no answer this. But now that is not there in this case. When it is this comes into impact, that expert can go through case file and he can refresh and relevant documents he can place in front of the court from his case register and say that these are also relevant. Okay, so that is the one plus point the experts have given. This is experts not based relevant to the case only. He is based on the available information he getting reports. On the basis he make the opinion. So there is no connection for him with the case. He is a third person. You don't have any personal contact with the case. But only when he says the opinion, everything he can't remember. Everything he can't reflect in the report also. He do so many things, but everything he can't make it. He only gives the opinion to the court. But now that the defense lawyer says that you have not mentioned this one, you have not mentioned this one. If I give the explanation, your judge may give the discretionary power, I voluntarily accepted or not voluntary statement. So finally, that is the one execute benefit has been given to the expert. He can go through the file and refresh his brain, and in the court also he can say that this is also relevant to. Okay, anyhow that court judge is the power to accept that my relevancy or not. That is this case, second thing. Okay, but he have a provision to say something. Opinion as to handwriting and signature when relevant. The same thing only under the handwriting signature here, special clause they have brought it. When the court has to form opinion as to person who by handwriting are signed, opinion of person appointed with the handwriting of the person whom it's supposed to be written, signed, and it was not written, signed by the person, it's relevant. In this one small thing they have indirectly added. Now, in order to depend upon the government expert only. Nowhere it is mentioned that means we need to have a government examiner say of examine karwana. Clearly says that who by the handwriting are signed, the opinion of the person appointed with the handwriting of the person who is supposed to be written as signed. He didn't say that means your opinion should be only government experts. So indirectly government has incorporated private agencies. Now you can go and get the handwriting signature opinion, can you get it done by the private agencies also, private persons also, who have it, only has to prove that means I am very familiar with the handwriting examination. Okay. That is the thing it has been. Only has to prove that he is an expert. Opinion and relationship relevant. So this is also it is not basically not the science, but just I added when we are talking about related psychology. So further I added further talk about psychology topics also. So for the psychologist also, when the court has to form an opinion relationship for one person to another, opinion experts will conduct as the existence of such relationship or any person who has member of the family otherwise and the special means of knowledge on the subject, it is relevant fact. Found in the damage and the boldness of the and BSA 45 grounds of opinion when relevant. Whenever the opinion of any living person is relevant, the grounds on which such opinion is based on also relevant. That is also again I said there two slides before also I mentioned. That means the any person who is the making the opinion on amalgamation of so much of documents. But he can't, everything can't be placed in front of the court, he make only opinion to the court. But when it is a court believe that means he can go through those relevant material and he can bring forth to the court and he can present those things as a relevant also. That is the one provision it has given. proof of the contents of document. Content of document will include either the primary or the secondary evidence. It is already you know that this I don't need to mention what is the primary evidence and secondary evidence. But in this one you will go through that please. What is primary evidence? The definition of primary evidence has been changed. Earlier, electronic evidence is not comes under the primary evidence. It is always with the secondary evidence. But now here it is. Some things it has been incorporated as a primary evidence. So finally, wherever the red marks is there, it may be photography, lithography, and printing. These are all comes under the primary evidence. Electronic explanations they have given. Primary evidence means the document itself produced by the inspection of the court. So all electronic evidences are now it is not a secondary evidence, it is a primary evidence itself. Electronic digital record created or stored, electronic digital record produced from the proper custody chain of such electronic or digital record may be primary evidence unless it is disputed. उसके ऊपर dispute नहीं है, then those are all considered as a primary evidence. Electronic digital record is stored in a multiple storages space in a computer resources or such as automated storages including temporary files in a primary evidence is a primary evidence. So that is the primary evidence has been segregated, defined. IT Act always the digital evidence is a secondary evidence. Business we are brought a copy we are making, but here it is they are making as a primary evidence. That is the basic difference they have brought it. Secondary evidence evidence of the person who is examined document or original which consists of numerous accounts such documents consistence of the examined in the court and who is skilled in the examination of such documents. So it is on the basis of some documents he make an opinion, then that is a secondary evidence. So all experts' opinions are all become a secondary evidence now. Experts' opinions are secondary evidence. The reason is he is making the opinion on the basis of some primary evidences and he make a opinion these are all authentic or integrally correct. So that experts' opinions are secondary evidences. BSS 61 electronic or digital records. Nothing in this adhiniyam. Nothing in this adhiniyam shall apply to deny the admissibility of electronic or digital record in evidence on the ground that it is an electronic or digital record and such record shall subject to section 63 even the same legal effect, validity and enforceability of other documents. So as per the IT Act, it is one thing else it is there, but in this one it is under 61, it has been all electronic records are considered admissible as a electronic evidences. And electronic records, the content of electronic may be provided in accordance with the provision of. So for anything electronic evidence you wanted to submit, but you need to follow section 63. So what is 63? What it says? Electronic 63(1) says that notwithstanding anything contained in the adhiniyam, any information contains electronic record which is printed or paper or stored or recorded or copied in optical or magnetic media or semiconductor memory which is produced by the computer or any communication device or otherwise stored, recorded or copied in any electronic form therein of referred to the computer output. Okay, such and such. Admissible shall be deemed to be also be a document. Already document definition has been changed. So according to that, it is all are admissible in the as a documents. Shall be deemed to be also if the condition mentioned in this section are satisfied relevant to the information and the computer in question shall be admissible in any proceedings without further proof of production of original or evidence or any content of original or any such fact stayed within that which direct evidence may be admissible. So that condition, what is that condition? The condition referred to subsection 1 in respect to computer output shall be following, namely the computer output contains the information was produced by the computer or communication device during the period over which the computer or communication device was used regularly to create, store or process information for the purpose of any activity regularly carried out an overall period of person having lawful control over the use of computer communication device. It is already mentioned in 65B in the IT Act. The same thing it has been brought it here also. Okay. During this set period, the information this kind kind containing the electronic record of the kind from which the information is so contained in the derived was regularly fed into the computer. The communication device is the ordinary course of said activity. This is also there in the 65B. What are the things has to be followed in the as per the 65B certificate formation? So, though the material part of the said period, the computer or communication device was operating properly, or if not, then in respect of any period in which it was not operating properly, was in operating during the part of the period, was no such effect of electronic record or accuracy if the content and information contained in the electronic record reduced or derived from such information fed into computer communication device is the ordinary course of said activities. These are all need to be mentioned when you are making the digital recording you are collecting. Whenever over the period the function creating, stored, processing information purpose enacted regularly carried out was the period of mention, and subsection was regularly formed by means of a one or more computer communication devices such and such. Those are all mentioned. It is mentioned communication devices. So these are all subsections. It is already I don't need to mention, but finally I will say that means they need to generate one document. Okay, already in the WhatsApp group I already have received I think this document. आपके WhatsApp में ये document मैंने भेजा हुआ आया नहीं आया पूछ ले देख ले आया ना एक certificate. So this is the certificate it need to be generated by the earlier 65B only one person has to give it, but here is the two people need to give the certificate. One is the person who holding that electronic information. One who is the person collected the information. Two people need to give the certificate now. किसने hold करके रख रहे वो data को वो एक certificate देना party है. इसमें what are the things are there? It is all information, name and all those things. What it has been down and only IME number, it is a make, serial number, whatever the things are, it is there. All those things has to mention, but finally he has to mention one more thing. Hash value, it is there. State that hash value of the electronic digital record. Any one out of obtained through the following algorithm. Uska hash value generate karna. So that is the party A, means that is the owner who is holding that electronic material. He has to give that hash value. Who is received, transferred into one pen drive or something else. The reason is you need to carry it to the court. So it cannot compute, so cannot carry it. So for that, who transfer that material into any other mode, that person has to give the part B. Okay, these two people has to do the job for creating these two things. Okay.
Sir, evidence expert opinion दे रहे हैं सर, उनका report तो primary evidence है. On the basis of that report, the expert opinion giving their statement in the court, then the opinion, how the opinion is the secondary evidence. So on the basis of report, if report is primary evidence, then उसका opinion कैसे secondary evidence?
Reason is what the if it is a mobile.
Sir.
Mobile is a primary evidence.
Sir.
Then mobile also primary evidence and expert opinion also primary evidence. It will be possible. Two primary evidence एक ही material के ऊपर कैसे हो सकते हैं? मैं तो वही तो पूछ रहा हूँ. I got it. I got it. That I am talking about electronic information. I am talking only, not other opinions. Okay. If another opinion also I say that means if bullet is the primary evidence. On that basis, he is framing the opinion. Then automatically it cannot be a main opinion. Bullet is the main opinion, main evidence. On that basis, he is adding his opinion. Furtherly, he is giving secondary level. His integrity is normally we are always saying the expert opinion is the corroborative evidence. But to avoid that corroborative evidence, now he is the court. This Adniam says that it considers as secondary evidence. Earlier, we used to say that it is not the primary evidence, secondary evidence. It is a corroborative evidence. Expert opinions are all corroborative evidence. Now that category has been removed. Now they say that it is a expert opinions are secondary evidence. Okay. So at least they have, I don't know exactly it is a promotion or demotion.
Sir,
You need-
in this respect, I want to add one thing.
Hmm.
Whenever the electronic device itself produced, it is a primary evidence. Suppose, sir, I capture the videography of a scene and I produced before the IO my mobile. So the mobile became, through the mobile I captured the video, I produced it before the IO and IO seized it. So certificate is not required.
You submitted mobile or the
I
video?
submitted, I saw the video recorded.
Showed-
I saw the video to the IO captured by my mobile and produced before the IO. to
Which
see
one you produced? Your
My
mobile you
mobile, my
proposed or
mobile.
video?
My mobile containing the video.
नहीं, तो वो ठीक है, मोबाइल में रहेगा तो मोबाइल तो वीडियो रहेगा.
mobile
You
containing the
mobile
video.
itself you are handling.
So I produced
It is a primary evidence.
primary evidence.
Hmm.
So, sir, how this document can be proved? Because after 2 to 3 years, sir,
That is
it might have damaged.
That is why.
It might have damaged
That is why I am telling. For that only.
the video, the battery.
Got it. That is only. It is already last 5 years. The same question is raised by so many people. So many experts are given. Reason is for that only they are given. That means you make a copy and take a 65B certificate. Okay.
Then
As a right. Huh?
The production of primary evidence is valueless.
No, it is not the primary
How, sir?
evidence. When he can't, sometimes he cannot hold on the long period. Simple, give you an example. CCTV footage. When CCTV footage is recording, after 15 days you don't get the same old data. Then I should just miss what I should do now. If it is a big parlor, big campus, there are server is there. In the server, there all the CCTV footage stored. Should I seize the server?
That means, sir, we will.
Then what I
reach
should
the-
do? In that way, please listen. I agree. Listen. My answer. If it is not possible, what need to be done as a proper true citizen? I need to copy that only. For that section has been given in the IT Act 65B. Okay. Now the same section provision has been given. Why you need to hold on that mobile? You copy it, that file only required. Generate the hash value of that file. That file is served. File is important, not your mobile. It is true or not? Which is important? File is important or the mobile is important?
No, file is important, mobile is important. I am telling, sir.
Mobile is not
So
important.
far as, sir, primary evidence is concerned, the mobile is important. So,
अरे बापा इसी में तो बोला है एविडेंस को डेफिनेशन चेंज किया है अर्लियर एविडेंस इज डेफिनेशन इज डिफरेंट नाउ एविडेंस डेफिनेशन हैज बीन चेंज्ड सो इलेक्ट्रॉनिक ट्रांसमिटेड इंफॉर्मेशन इज एविडेंस डॉक्यूमेंट में तो पहले डेफिनेशन को दोबारा जाना पड़ेगा आपको डेफिनेशन ऑफ द इलेक्ट्रॉनिक डॉक्यूमेंट की डेफिनेशन क्या है सुनना एक बार दोबारा अब पूरा क्लास सुनने के बाद दोबारा पहले क्वेश्चन को जाएगा तो कैसे है जस्ट 1 मिनट 2-3 स्लाइड से हो जाएगा हो गए 2-3 स्लाइड्स आई विल कवर ओके जस्ट कंप्लीट BSA 65 only 2-3 slides are there only I will complete it the handwriting so it is mentioned you can go through the BSA 65 proof of electronic signature that is all I try to discuss okay in the afternoon I will discuss this one okay in detail okay these two things I will discuss later on okay no problem so T is more important than हम होगा तो नॉलेज है हम नहीं होगा तो नॉलेज किधर से आएगा पहले हम होना चाहिए सही ना सो चाय होना है उसके लिए थैंक यू वेरी मच फॉर योर सपोर्ट एंड listening me last 1.5 hours so thank you nice of you for everyone sparing your time
Singh from National University of Juridical Science, West Bengal. Madam will be taking 2 consecutive classes before the lunch and post lunch. And during both the classes, she will be dealing with the topics as I was discussing. She'll be dealing with an overview of the Bharatiya Nyaya Samhita 2023, additions, modifications, recognitions, reorganization of chapter and sections, and thereafter the relevance of the new crimes introduced as a means of to address the contemporary challenges and punishment schemes under the BNS. These are very important topics. So it will be a very interesting 2 sessions for all of us. Madam, on behalf of Odisha Judicial Academy, I welcome you as the resource person for the classes. And I have the pleasure of requesting Prachi Prabhananda, Assistant Public Prosecutor, Banpur, to kindly felicitate Madam with a bouquet of flowers from our side. Thank you. Without wasting much time, I would like to request our resource person to kindly start the deliberation. Yes, yes, you can directly, you can take from here. You can use the lapel mic to.
Better if I stand here.
Okay.
This one, I think this 8. This one. That would do. Acha. Okay. Yes. I will be here only. I hope I am audible to all. So very good morning all. Actually, it's afternoon, but we are meeting for the first time. So it can be good morning or good afternoon. At the very outset, I would like to thank the organizing team, especially the Odisha Judicial Academy, for inviting me. It was very humble of sir to actually give me my introduction. From my LLB days, I was very interested in criminal law, and my publications and researches are all in criminal law. So to start with, what I have thought, in the timetable, the 2 classes are divided into 2 different ways, but or the topics are the same. But I'm going to discuss only it is that we'll start the changes which have been introduced in the Nyaya Samhita. So and it will cover all whatever topics are mentioned in the 2 class sessions. Will be covering all. So and section wise we are doing the changes which are being introduced. So punishments changes will do, and which is there in the second half. So will not go the manner in which the timetable shows, will go as the changes are there in the Nyaya Samhita. That is only the change. And to start with, if we say what changes have been introduced, in mostly all the sections, the address of the offense has been changed. So murder was there in 300, has changed its address to 101. So that change is there. That we will have to be acquainted with. That will take time, because now Indian Penal Code was in our fingertips. Here, this will also in few months or days, we will remember all the offenses in fingertips. So to start with, if I say what are the major changes, in the major changes in the Nyaya Samhita, we find that the law has been first the title of the law has changed. That is the Bharatiya Nyaya Samhita 2023. 19 provisions that existed in Indian Penal Code have been omitted. So 19 offenses from the Indian Penal Code have been omitted. 33 offenses, the punishment of imprisonment has been enhanced. 23 offenses, the mandatory minimum punishment has been introduced. one important change which you all know, that community sentence is a sentence introduced in the punishment chapter. So we will do the offenses. There are only 6 offenses for which community sentence is the punishment. So that we will be doing in course of our discussion. So what we find that fine and punishment for various offenses has been suitably enhanced. 1860 Indian Penal Code had very less amount of fine. So mostly 3,000, 5,000, 1,000 rupees increase, and some have been left to the judges to decide what will be the quantum of fine. So that is this is in a nutshell the changes which are there. Now we will look into as to how to go about the changes. Now, before I go to the title and the commencement, what we will find that there is one very unique section in the penal code, and in that penal code, if I talk about this particular section, that is the repeal and saving sections. Do you have the Bare Act with you? Okay. Bare Act, I can show it here. एक मिनट. नहीं नहीं, मेरे पास Bare Act है. मैं आप लोगों को वो बताना चाहती थी.
We have not supplied, ma'am.
Huh?
We have not supplied any document.
You should have actually got it. I don't know how to actually minimize. It was there in my pen drive. नहीं नहीं, उसमें रिपील सेक्शन का यूनिकनेस क्या है कि हमारा जो पुराना इन्वेस्टिगेशन वाज गोइंग ऑन इन द ओल्ड लॉ, दैट विल कंटिन्यू. दैट इज देयर इन सेक्शन 358 रिपील एंड सेविंग सेक्शंस को मिनिमाइज कर. अच्छा, ये नीचे था. ओके, मेरा वो पेन ड्राइव में है. पेन ड्राइव है ना यहाँ पे, यहाँ पे नहीं नहीं, क्या होता है माई यहाँ पे ये 2 नंबर PDF. हाँ हाँ. See, the soft copy I have kept it here, so you can email yourself from here, so that you can use it. It will be there in mobile, and in this book, this Bharatiya, this taxman book, at the towards the end there is one app, so you can actually scan that app. The entire law will be there in your mobile, so that app is also there. You check here, and so taxman has come up with a very unique idea here. The control F. एक मिनट रुकिए, कंट्रोल F मुझे यहाँ पे लिखना है. You all of you can see this, or should I make it little big?
Zoom it.
हाँ, ये तो दिख रहा होगा उनको. You all can see, right? ये वाला पोर्शन को थोड़ा बड़ा करना है. हाँ, you all can see now. Nothing, notwithstanding the repeal of the code, that means Indian Penal Code has been henceforth repealed. But there is a saving clause here which talks about that it will not affect. You come to D and E. Any investigation or remedy in respect of such penalty or punishment, any proceeding, that is E, investigation or remedy in respect of such penalty or punishment as aforesaid, and any such proceedings or remedy may be instituted, constituted or enforced, and any such penalty may be imposed as if code has not been repealed. So we are having 2 systems parallelly running at the time when this new law has been enforced. So new law cannot be retrospectively applicable. That you know, criminal law cannot be retrospectively applicable. Therefore, from 1st July 2024, on new offenses, new sections, investigations will start. As I have told you, most of the section remains the same. Even the comma and the full stops are same. So there is no change, only address changes there. Address means section number. So what are the changes today? In the sessions which I'm going to take, I'll just highlight. I will give you my mobile number. If you have any problem, I'll give you my email ID. You can contact me later on also when you are in having any problem, when you are addressing certain issues relating to understanding of the law. So this is what we need to know. So as the legislature did not have any option, the criminal law cannot be retrospectively applicable. So the old investigation will continue. Now, short title and commencement and application, which every law has. Every person shall be liable to punishment under this Sanhita and not otherwise for every act or omission contrary to the provision thereof, of which he shall be guilty within India. Now, act or omission was defined earlier, and act or omission is still defined here in the new law. And in the new law, if we talk about the change in the sections of act and omission, here the act and omission were earlier given in section 33 of the Indian Penal Code. Now it is given under section 2.1 and 225. Act is in 2.1 and omission is in 225. So this is only the change, but even the comma and the full stops are remaining the same. So there's no change in it. Only the number has been changed. Now, any person liable by any law for the time being in force in India to be tried for an offense committed beyond India shall be dealt with according to the provision of Sanhita for any act committed beyond India in the same manner as if it has been committed within India. So this was earlier also there, now also replicated. The provision of the Sanhita shall also apply to any offense committed by any citizen of India in any place without and beyond India. So Indian citizen committing crime in America, England, Sri Lanka, that person will be liable according to the Sanhita. Now, if the Sri Lankan law or the American law or the British law is actually having same offense triable, then we will not again try him for the same offense. But if it is not punishable there, no offense there, still we have the power. Any person or any ship or aircraft registered in India, wherever it may be. So this was also earlier there. Any registered ship in India, there in high sea in any part of the country will be liable for any crime committed on that aircraft or ship. Now here you must remember, if within 20 nautical miles any ship or aircraft is there of a foreign country, there within Indian 20 nautical miles, or in those if crime has been committed, it will be considered as if crime committed in India, and India will have the right to try those cases. Now, any person in any place without and beyond India committing offense targeting computer resource located in India, this is a new addition. This clause C, this is a new addition. Any person in any place without and beyond India committing offense targeting computer located in India. So say any South African country is actually targeting a computer in Qatar. That will be an offense. Sir. The beyond India, It does not make much difference, sir. That means beyond the jurisdiction of India, outside India. So they have used a word which is synonymous to each other. There is no particular, what we need to understand, there is a demarcated jurisdiction of our country. And the person and this cyber crime is committed in a virtual world from a distant place, or it can be within India also. So here, without and beyond India is, server can be located anywhere in the world, and the person having access to the server can be there in any other part of the world. Okay, so through which server, what he is doing, which country, say server is in one country and criminal is in another country. So where are we going to locate for the criminal? We are going to locate the criminal where the criminal IP address is there, not the country in which where server is there, right? So that is why without and beyond India word is used. That much we need to understand. Any confusion? Others? Okay. So explanation is there. The word offense includes every act committed outside India, which if committed in India would be punishable under the Sanhita. Now offense is also defined under the law. If you see, offense was earlier also defined under the law. Here also offense has been defined in the new law. So actual section of offense बहुत पीछे चले गए हैं. I'll come to that. So A, who is a citizen of India, commits a murder in any place without and beyond India. Now he can be tried and convicted of murder in any place in India in which he may be found. So sometimes criminals commit crime outside India and come and take rescue in a shelter in our country. So that is also taken care of under this law, and nothing in this Sanhita shall affect the provision of any act for punishing mutiny and desertion of officers, soldiers, sailors or airmen in the service of Government of India or provision of any special or local law. So this was earlier also there, now also there, that the army personnel and the paramilitary forces will be tried according to their law, and their law is court martial. Their law is Army Act, Navy Act, Air Force Act, and the special act for the paramilitary forces. So in totality, there are 20 chapters, 358 sections, and all I'm not going to discuss. The changes only I will discuss. So what new addition is there? And in the new edition, we have defined the child. Child was not there in the Indian Penal Code. So child has been defined under section 2, subsection 3, defined as child means a person below the age of 18 years. Now, how do we calculate below 18? Any one of you have got tried cases in juvenile board? Juvenile board, any one of you? Why? We should actually, you would have used the word completed. The mistake which the legislature has done below or under. Below or word under creates confusion. So either he has stepped into the 18 or he has completed 18. How here we will understand below means he has stepped into 18. And sir is right that we should have used the word completed. And when, sir, how that we are, how do we determine the age? और सर ने कहा कि 17 साल हो जाएगा, फिर 18 में पाँव देगा तो हो जाएगा। तो पाँव हम आप 17 आपने क्या बोला? व्हाट डिड यू से? हाँ, we do in India we do not celebrate the zero birthday. Zero birthday is celebrated on completion of 1 year. So that means he has already stepped into 18. He has stepped into 18, lived for 365 days before the midnight. He is still a juvenile. हाँ, 12 before 12 PM. अरे अगर 5 मिनट 11:55, 11:56, 11:57, 11:58, 11:59, he is juvenile. 60 हो गया तो फिर वो that is what the before. Now talking about document. In document we are having changes. In document, section 2 subsection 8, document means any person, any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of those means, and includes electronic and digital record intended to be used or which may be used as evidence of that matter. Here we have added the word electronic and digital record. I'll explain electronic and digital record. I have another slide for that. So explanation 1 talks about it is a material by what means or upon what substance the letters, figures or marks are formed, or whether the evidence is intended for or may be used in court or not. Explanation 2, actually typo error. Whatever is expressed by means of letters, figures or marks as explained by mercantile or other uses shall be deemed to be expressed by such letters, figures or marks within the meaning of this section, although the same may be letters, figures or marks, all not be actually expressed. So let's see what is electronic and digital record. What do we mean by that? Now, digital documents are very similar to paper documents. So what we do, we just take a printout of it. So although a digital document can be viewed on an electronic device, it's pretty much looks the same as it would on the piece of paper. Now, because of this, even when company receives a digital document, it's common for it to be printed. It is looks like similar. Now, unlike a digital document, an electronic document is pure data. This makes it difficult for an untrained eye to interpret. So layman will not be able to interpret that. We need an expert person to interpret that electronic documents. So that's primarily because a document is in an electronic form is meant to be understood by a computer. In other words, electronic data is meant to be transferred from one system to another without human intervention. So suppose when a document has a digital signature. So what do we understand by a digital signature? That means the authorities who have given you the digital signature, authorized digital signature, they will provide you with a password and a key. So the person who is receiving the key along with the document can actually open the document. So that is, say if that document is received by you and me, we will not be able to open that document. Only authorized digital signatory sending the key. So that it is a lock and key. The person having the authorized digital signature can lock the document. Person receiving have to be given the key to open the document. Then only it will be actually opened. So it can be a normal document, that is a paper document, but like paper document, but it has been locked with a key. Then it becomes a electronic document. Or sometimes the terrorist uses, they send photos, and within the photos, they encrypt certain messages in forms of letters, colors, different types of images. Now, a layman will not be able to encrypt or decrypt the encryption. So that can only be done by an expert. So that document will then become a electronic document. So there are forensic experts. They will also explain in much more detail in the sessions to come. So this makes it difficult for an untrained eye to interpret. That's primarily because a document in an electronic form is meant to be understood by computer. In other words, electronic data is meant to be transferred from one system to another without human intervention. So we have actually then removed lot of definitions like, servant of the government, a definition of government of India, but we have retained the definition of government, which was earlier section 2 subsection 17. Now it has become 2 subsection 12. Here we have added a new definition of court under 2.5. So we had definition of judge, but we did not have definition of court. So now under subsection 2 subsection 5, we have defined what is a court. So court means a judge who is empowered by law to act judicially alone, or a body of judges which is empowered by law to act judiciously as a body when such judge or body of judges is acting judiciously. So this is a new addition. Now in the definition of gender, earlier gender was defined under section 2 subsection 8. Now we are defining it under 2 subsection 10, and we have added the word transgender. So pronoun he as a derivative are used for any person, whether male or female, or transgender. So transgender has been added in the penal code. So say if it is a murder, or if it is a different types of offenses, for all transgenders will be coming in. We will be using transgender as well. Now offenses abetted outside India. This is a new addition in the sense section 48. A person abets an offense within the meaning of this Sanhita who, without and beyond India, abets the commission of any act in India which would constitute an offense if committed in India. Now here you will have to remember one more thing, which I should have started in the beginning only and told you, that in the new Sanhita, we have added chapter 4. In chapter 4, we have clubbed first offense abatement, starting from section 45 to section 60. From 45 to 60, the entire abatement chapter. In section 61, we have introduced conspiracy. So 120A and 120B has now been clubbed under section 60. So section 60 is conspiracy now. And section 62, which was 511 IPC. Section 511 has now become section 62. So wordings and everything remain same, no change. Law remains same, but they have clubbed it in one chapter, that is chapter 4, all the principles, criminal law principles, and those principles relating to incomplete crime, inchoate crime, abatement, conspiracy, and attempt are all inchoate crime, incomplete crime, and they are punishable. So as we all know that there are 4 stages of crime, And in the fourth stage is the final commission, is the fourth stage. But in this crime, the third stage is attempt, but second stage is you can say preparation. Second stage is preparation. First stage is a just intention to commit or making a design. हम करेंगे. But preparation, offense of preparation is punishable under conspiracy. If it is a conspiracy, then mere preparation is enough to punish. Attempt is also not required. There are many offenses, sir. I'm just telling. I'm giving you example. Preparation of dacoity, robbery, mutiny. So those are there. I'm giving you one example. So these inchoate crimes now have changed their address. They have come are clubbed under chapter 4. Okay. So here we have actually added this offense abetted outside India. And if the person is sitting outside and trying to abet a crime in India, any offense in India, and this is directly linked with, now we are having, will come to the offenses like terrorism and organized crime. So in terrorism and organized crime, even in human trafficking also, we find that people are abetting these crimes sitting outside the country. So to book them for punishment and clubbing them, like read with abatement sections, we are going to make a case offense against the accused. Now, as I told you, sir, that in the class timetable, punishment was there in the second half, but in the chronological of the discussion, or changes, punishment is in the beginning only, section 4. So that's why I'm discussing it here. Okay. So here, as we all know, that there is no change. No change in the sense, all the punishment remain the same. Unlike death, imprisonment for life, imprisonment which is of two description, rigorous, that is with hard labor, or simple, forfeiture of property and fine remains same. Principles relating to that also remain same. So prosecution needs to prove beyond reasonable doubt the guilt of the accused, remains same. Highlighting the mitigating factors and the aggravating factors remain same to determine between death penalty and life imprisonment. Okay, there is no change. Proving beyond reasonable doubt guilt of the accused, and also prove that the accused cannot be reformed and rehabilitated. Three cases, 3 types of cases: crime against humanity, crime against women and child, and crime against state. In these 3 cases, 3 types of cases, proving beyond reasonable doubt guilt of the accused, and also prove that the accused cannot be reformed and rehabilitated, death penalty. Prosecutors needs to prove that, to sir, you all know. So what is the new change? And also in case of life imprisonment, there are judgments from Supreme Court which says if it is life imprisonment, then it would always mean with hard labor, right? Rigorous, hard labor. If there is imprisonment of any other description other than life, then it can be rigorous or simple. Or partly? Partly rigorous and partly simple. So there is no change in those principles. Change is addition of community service. In community service, these are the 6 offenses. In these 6 offenses, we have added community service. Now, we don't know, or we are not aware as to what type of community service the judges are going to give. So there is an open. No, I have put it back, sir, because community service is F. So that's why I have. I'll explain all of those offenses. I was explaining as to what is how community sentence will be passed. Community service sentence will be passed. Now, what we see, the concept which is there in the Western world, where we are currently, if we see and study, will find that the accused is made to stay with the family, aggrieved party, victim family. And the victim has to undergo, the accused has to undergo the pain and agony which the victim's family is undergoing. Now, in India, it is not possible, or there can be abuse. Who will keep a check and balance? Vice versa can also be there. The accused is also again abusing the family. And our probation system is very unfruitful. I will rather say it is not working properly, and the state's reluctance to strengthen the system is also not there, because for a big district, if we have one probation officer, how can that probation officer manage things? And our probation officers do not have infrastructure, manpower, and budgetary allocation. The salaries are also paid delayed by 3 months, 6 months, 1 year. They will be reluctant to actually. They would be reluctant to actually continue with it. So here, and one example I will state from that Bihar incident. One of the judges from the subordinate judiciary had actually given an order, you must have read in the newspaper, for outraging modesty of women to clean the clothes. He was a washerwoman man, so he was asked to clean clothes. After the day the sentence was passed, the very next day the judge was suspended. So, it was not fair on the part also to judge to actually give such kind of punishment, where the man had actually outraged the modesty of the women. So, how are we going to implement? I am very much apprehensive about it, and there are no parameters set which they have to go through while passing the community center. Now, all these offenses which are mentioned here, 6 offense, they are all petty offenses. They are not serious offense, neither they are a heinous offense. All these offenses are petty offenses, you can say. And if we go by one, 202, I'll just read out from here 202. In 202, we are having public servant illegally engaging in trade. So illegally engaging in trade, that is whoever being a public servant and being legally bound as public servant not to engage in trade, engages in trade, shall be punished with simple imprisonment for a term which may extend to 1 year, or with fine, or with both, or with community service.
Then simple one question.
Sir.
In the prosecutor, if we satisfy that the court is going to get the punishment of community service to the accused, what type of community service will suggest?
That is to what I am apprehension about. No, I am apprehensive about. What should be? Like, when I am there in the POSH committee, sexual harassment committee, I ask the perpetrator to do some, say service in the hospital, take care of patients. I ask these, especially I am in a POSH committees in the educational institutions. So mostly the perpetrators are students. So I ask them to give free service to 7 days in some hospital and get from this hospital superintendent one certificate that you have actually engaged in helping the patients during those 7 days. It can be a 5-hour or 5 to 7 hour service. I have passed like that. Now, how can, what type of community service will our judges pass we will have to wait and see, and there has to be rules relating to it.
Very long time, madam, when Raja was asked to wash the food in front of temple. That was there.
And serving food in the gold sovereign temple will also be working.
That is the community service.
That is community serving. Or, sir, providing the juvenile home, children facilities. Those type of. But, the problem is that our country people are so fraud making people, like they will engage in some kind of cheating. Some kind of cheating. So how are we going to actually monitor? What will be the surveillance system? That the person has really done the community service. Or cleaning the roads. Sometimes I give punishment that you have to go and help the traffic police. Planting more trees. But after planting, who is taking care of those trees?
And for maintenance for 1 year.
And here we are talking about public servant who has engaged in illegal trade.
Next one.
Yes,
Circumstances,
sir, yes.
our
That is
nature or
what,
character of the
we will have to wait and see. True. Then section 209 talks about non-appearance in response to proclamation under section 84. Section 84 in the Bharatiya Nyaya Sanhita talks about proclamation. So according how proclamation will be done. So if there is a non-appearance in the response to proclamation under section 84, then community service will be there. 206. So 209. That is non-appearance in response to proclamation. Whoever fails to appear in a specified place and a specified time as required by the proclamation published under subsection 1 of section 84 of Bharatiya Suraksha Sanhita 2023 shall be punished with imprisonment for a term which may extend to 3 years or with fine or both or with community service. So here you will find that we will have to check in the, I have not checked, sir. If you, sir, can check. This is 3 years punishment. That means which may extend to 3 years. So extend to 3 years, and this also there along with fine there can be community service. Then we are having section 226. This happens, when police goes to arrest or police goes for search and seizure on some particular location. There the person actually threatens that he will commit suicide and does not allow the legal proceedings to happen. Kya hai, sir? Cognizable. Non-bailable and cognizable. Okay. So coming to section 226, here attempts to commit suicide to compel or restrain exercise of lawful power, and whoever attempts to commit suicide with intent to compel or restrain any public servant from discharging his official duty shall be punished with simple imprisonment for a term which may extend to 1 year with fine or with both or with community service. So section 226, let me see if it is cognizable or bailable. I know. It is non-bailable, non-cognizable and bailable.
Yeah.
Sir. Sir. And there also in the Suraksha Sanhita, there is changes. Yesterday, Sarfraz must have talked about it. So he was supposed to do. There is a change there also. Now coming to section 303. In 303, which was 378, punishable under 379. So they have actually now clubbed it under section 303, subsection 2, proviso. In the proviso, they have added, that is 3023, subsection 2. In subsection 2, the punishment for theft is given, that is 379. And there they have added one proviso. In the proviso, they have actually said given community service as punishment. So 303 subsection 2, I'm reading the full thing because first part is for punishment and second proviso talks about punishment of community sentence. So first part is the same punishment which was there for theft earlier. There is no change in that. So whoever commits theft shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine or both. And in case of second or subsequent conviction of any person under this section, he shall be punished with rigorous imprisonment for a term which shall not be less than 1 year, but which may extend to 5 years and with fine. So minimum mandatory 1 year can go to the extent of 5 years and fine. So this is first part. And in the second part, proviso, that is, provided that in the case of theft, where the value of stolen property is less than 5,000 rupees and person is convicted for the first time, shall upon return of value of property or restoration of stolen property shall be punished with community service. So giving an opportunity to get reformed, apna galti ko maan lena. Okay, and then he will be condoned with community service. Then we have 3. That or is there, sir? No, in between or is there. अगर नहीं भी किया, अब मान लीजिए बेच दिया है, 5,000 रुपया का सामान को बेच दिया है, then what will happen? So then also it is said that or restoration of property. So it is not mandatory restoration. We come to 355. Making a false document. So making a false document. Sorry, 35. Sorry. 55. Sorry, sir. 55 is misconduct in public by a drunken person. Earlier, this was there in CRPC. 420 था ना भाई, CRPC 420 विलेज एरिया में drunken. IPC. Now we are having this as a for this misconduct in public by drunken person, whoever in state of intoxication appears in any public place or in any place which he is trespass in him to enter and there conducts himself in such a manner as to cause annoyance to any person shall be punished with simple imprisonment for a term which may extend to 24 hours or with fine which may extend to 1,000 rupees or with both or with community service. ये 3 idiot का जो इनसे scene है ना, there the students goes to the director's home and then pees there, and then the director comes out and finds out that kind of offences will automatically come in. So this is misconduct in public by a drunken person. And for defamation, in defamation defamation is there under section 356, and 356 all the provisions remain same. All the provision remains same. In defamation, punishment is given where there is punishment is actually under subsection 2. There are 3 types of punishment: subsection 2, subsection 3, subsection 4. for defamation. So the degree of offense is higher. So for the lesser type of degree, whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or with both, or with community service. So for the lowest degree of defamation, person can be punished, which is may extend to 2 years, but can also be punished with community service. So these are only 6 offenses where we are actually looking into as क्या कहते हैं, community service as punishment. Now, in case of commutation of sentence, which is the section number 5, earlier if I say earlier commutation of sentence 53 से शुरू होता था और कम्यूटेशन था 54, 55, 55A, 56. So all these 4 sections have been clubbed in one, that is section 5. So this is the change, but there is no other change. Commutation of sentence, appropriate government may without consent of the offender commute any punishment under the Sanhita to any other punishment in accordance with the section 474. That is the power to commute under Suraksha Sanhita. And here we must remember this much, that if the offender has committed offense punishable by state act under the state law, then governor has the power. Appropriate government is governor. If it is a central law, offender has committed an offense punishable by a central law, then the president. But that was earlier also there, now also. Now we have plugged almost 4 sections into one. An appropriate government लिखा हुआ है, so I have given you in that sense. When it will be death penalty, commuted to life imprisonment or any other description. If it is life imprisonment, then any other imprisonment. Now section 103 is a new addition. So 100 is culpable homicide, 101 is murder, 102 is murder by क्या कहते हैं, हाँ, culpable homicide not amounting to murder, and we are having 103, that is mob lynching. So mob lynching has been introduced as a new offense, and as a new offense, new punishment is also given. So 3 में है punishment for murder, and 4 में है punishment for murder by life penalty. So here we are doing 103. So 103, who have 103 में subsection 2 is talking about mob lynching. 1 remains same. Punishment for murder, first provision remains same. Whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. In the subsection, they are defining the crime and they are giving punishment for that. And the explanation or the ingredients are relating to mob lynching. Now, when a group of 5 or more acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life and shall also be liable to fine. So community, ये आपका violence, communal violence, all types of communal violence is taken care of. It was a long awaiting request that community violence, communal violence should be addressed in the Indian Penal Code, and they have addressed it in this way by putting it in a punishment under murder. So all of you understood this much?
Yes.
Now causing death by negligence, and I want to tell you that this was there, subsection 2 was there prior to the notification coming in. So in the notification, this subsection 2 of section 106 has not been notified. Okay? So it has not come into force. आपको पता होगा ना, जब ये नोट आया था तभी ट्रक ड्राइवर्स लोगों ने आंदोलन किया था, ऑल इंडिया स्ट्राइक, एंड द स्ट्राइक कॉज लॉट ऑफ लॉस टू द इंडियन इकोनॉमी, एंड देयरफॉर when the enforcement date was notified, in that notification only, in the second part of the notification, you will find except section 106 subsection 2. तो मैंने आपको इसीलिए यहाँ पे ऐड कर दिया है, otherwise there is no change. Okay? हाँ हाँ, it will be covered under 106(1) only. क्लॉज 1 में कवर हो जाए. और ये जो डॉक्टर्स का है ना, ये भी उठ जाएगा, कुछ दिन रुकिए. डॉक्टर्स will also be not liable. Wait for some time. Supreme Court only will come with hard hand. Wait for some time. 1 or 2 months cases will come up, and then so whoever causes death of any person, तो वो 304 A और B को यहाँ पे क्लब कर दिया, B नहीं A को, तो 304 A को पूरा यहाँ पे रख दिया है. Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years, and shall also be liable to fine. And if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years, and shall also be liable to fine. So this I am hoping that it will be rewritten or redone. So we will have to wait, and medical council or commission has defined who is a registered medical practitioner. According to that meaning, the explanation of registered medical practitioner will be taken care of. That's it. When this section is not notified only, we will wait for the time the notification comes in. And here, sir, that will also amount to reporting, as you have said rightly. If he doesn't report and stays there for the police to come, he will be lynched to death. Mob lynching will be there. And if he... No, I am telling, if he waits to report, phone, mobile, and now तो ना सुरक्षा संहिता talks about EFIR, है ना? आप लोगों को कल पढ़ा है? तो EFIR कर देगा वो कहीं से भी?
किसी पे इन्फॉर्म देना चाहिए.
इन्फॉर्म हो गया. ना, it should not attract, but ministry has not notified it only, no. So we will wait for the changes to be introduced. Now we come down to a new major change, that is 111. 111 has actually introduced organized crime. So all those syndicate crime which takes place, any kind of, in Bengali the word is used tolabaji, but I don't know in Odia what is the word. So you all will be better understanding what is what are syndicate crimes which are there, or small mafia, committing organized crime will all be clubbed under gangster crime. Yes, some state had Gangsters Act, but now all the states were not having. So now under this provision we will be able to book them for punishment, and there are higher punishment as well. So any continuing unlawful activity. Now unlawful activity is defined under the penal code, including kidnapping, robbery, vehicle theft, extortion. So under the umbrella of extortion, so many types of extortion will come in: land grabbing, contract killing, economic offense. Here I'll come to economic offense in detail later on. Cyber crime, trafficking of person, drugs, weapons or illicit goods and services, human trafficking for prostitution or ransom by any person or group of person acting in concert, singly or jointly, either as a member of organized crime syndicate or on behalf of such syndicate, by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including beneficial financial benefit, shall constitute organized crime. So this is subsection 1. This is subsection 1. A very, very wide, very, very big umbrella under which lot of offenses are covered. And each offense has a own clause, section, subsection in its own. So along with that, subsection 2 talks about continuing unlawful activity. So that may, in the first part, it could have been only one event. Now it is continuous event. Say sand mafia or say the drug mafia, weapon mafia. They are doing a continuous unlawful activity. So means an activity prohibited by law, which is cognizable offense, punishable with imprisonment for 3 years or more, undertaken by any person either singly or jointly as a member of an organized crime syndicate, or attempt to commit culpable homicide on behalf of such syndicate, in respect of which more than one charge sheet have been filed before the competent court within the period of 10 years, and that court has taken cognizance of such offense and includes economic offense. I have highlighted economic offense. Before I go and explain economic offense, here I want to point out that earlier we were waiting for the sentence of the court that he has been convicted for second term. But within the law only we are talking about that charge sheet has been filed and court has taken already cognizance in the bracket of the number of years also we have increased 10 years. So past 10 years, any one incident will also make the person continuing unlawful activity. So this bracket has been also explained by the legislature as to what amounts to a activity, unlawful activity, which is a continuing unlawful activity. Now economic offense.
Yes.
Sir.
So businesses concern.
Sir.
Earlier offense of right, whether will be included as a continuing offense or an organized crime.
So we will look into section 58, subsection 2. There it is said, earlier offenses. It would have a same meaning. इसलिए मैंने शुरू में ही आपको वो दिखाया था सर. देखो 58. Section 58, subsection 2. It will not, with this repeal of the code referred under subsection 1 shall not affect. यहाँ पे any क्या कहते हैं previous operation of the code so repealed or any duty done suffered there under. तो act आ जाएगा automatically. Got it? That is why in the beginning I discussed section 358. Okay. इसको इसीलिए मैंने बंद भी नहीं किया. So continuing unlawful activity का बाद में यहाँ last में you can see I have highlighted economic offense, and economic offense is given under subsection 3. Now there was a long awaiting demand that nowhere we are able to deal with the economic offenses, and therefore we need a law for it. So the law has been introduced in section 111 subsection 3. So economic offense includes criminal breach of trust, forgery, counterfeiting of currency notes, bank notes and government stamps, hawala transaction, mass marketing fraud, or running any scheme to defraud. Aapka Sarada, Narada in Bengal, what we had all will come under this category, chit fund scam. Then Bandhu diary case, where Dan Bandhu escape punishment, Telgi scam, stamp paper scam, all type of scam will come here. Doing any act in any manner with a view to defraud any bank or financial institution. So banking fraud, financial institutional frauds, all will come here. Credit card frauds, or any other institution or organization for obtaining monetary benefit in any form, So you can imagine a proper economic offense definition has been provided under section 111 subsection 3. Now punishment is given under section 111 subsection 2. And they are having categorized A, B. So whoever commits organized crime shall, if such offense has resulted in death of any person, be punished with death or imprisonment for life, and shall also be liable to fine, which shall not be less than 10 lakh rupees. So here fine is minimum mandatory 10 lakhs. Huge amount of fine. But human trafficking वालों के लिए कुछ नहीं है, या organized criminal syndicates के लिए कुछ नहीं है. In any other case shall be punished with imprisonment for a term which shall not be less than 5 years. So minimum mandatory 5 years, but which may extend to imprisonment for life, and shall also be liable to fine, which shall not be less than 5 lakh rupees. So minimum 5 lakhs, judge can give more than that also. Discretion has been given to the judge. Sir? हाँ पीएमएलए का केस आपको देखिए ना, यूएपीए का केस भी आप लोगों को दे दिया है. And who is going to decide? Who is going to decide? State is going to decide. State has been given power. The case will be handled by local police, or state will be handled by specialized agency.
Economic offense means that.
So what happens, there would have been some, there would have been some gap from the detection of the crime to the investigation start. So the time lapse. Here in these cases, time lapses will not be there. Immediately you will take over. Your investigating agency will take over state, and they will collect. And if they feel that there is a need for a specialized agency to investigate, then it would handle. Or otherwise, court will interfere. Court intervention. Now you are not able to handle. Give it to the specialized agency. इसमें दो तरह का भी चीज हो सकता है, या तो केस खराब हो गया या तो केस strengthen हो गया. But legislature intends to strengthen the case. Otherwise, best example if I give of spoiling the case is the Arushi murder case. Arushi murder case, state investigation actually spoiled completely, and the dentist family was dentist of the chief minister. So how could your investigation be handled so properly? Okay, and whatever flaws they created in the investigation, CBI could not recover later on. So it can happen both ways. We will wait and see. We will have a lot of materials to discuss in the class, because we need to take too many classes. So in the too many classes, what are we going to discuss if we don't have materials to discuss? So let's wait and see. Now, defining organized crime I have actually done an explanation to whatever it is there in the law. This slide is just an explanation of the offense. So most obvious distinction between organized crime and any other form of crime conduct is it is organized. Organized, that means proper planning, how to be executed, who will execute what, identifying that. A single person will do it or a group of people will do it. So that proper planning. So in general term, it does not include random, unplanned, individual criminal acts. Instead, it focuses exclusively on planned, rational act that reflects the effort of groups of individuals. Several efforts have been made to elicit common elements to describe and define organized crime with greater specificity. A list of all crimes committed by organized criminal groups would be outdated quickly as social, political, and technological changes result in changing opportunities for crime in different locations. Like organized crime started from the Second World War, post-Second World War, because all the organized crime like hoarding of food, essential commodities, or creating a scarcity in the market and then selling the products in a higher price. It depends upon place to place, time and kind of need. So that's how it grows. Now a lot of syndicates are doing cyber fraud, cyber crimes. So this depends upon the technological changes, social and political changes, and result in changing opportunity for crime in different locations, like the border area, drug trafficking, human trafficking, or you can say arms trafficking taking place. So it depends upon location. And therefore, the unit of analysis in most definition is not the offense, but the offender and organized criminal group. So a better understanding of the nature of these groups will help in developing more effective response to them. And there are many definitions of organized crime. IPC has been Sanhita has taken a unique definition, but what we find, it has relevance from the book written by Albanese. And here these characters include the purpose of organized crime to financially profit through crime. So economic offenses, other than all the other previous two offenses, are relating to creating profit illegally. And organized crime mainly responds to public demand for service. The corruption is an enabled and protects organized crime operation, sometimes intimidating threat, and forces are also needed to protect those operations. These elements comprise organized crime as continuing criminal enterprise. Now this is the manner it is done, and in the first part you will see there is no relationship. In the alliance and operation is there in second, and convergence is there in the third. And this is actually taken from the United Nations modules on training on organized crime. So how they have identified it in three manner. And in the first, they talk about terrorist activities, drug trafficking, human trafficking, remain independent but operate within some area. So there are pockets in which they function. Alliance and operational relationship, terrorist and criminal groups form a mutually beneficial alliance and exchange operational support. And in the third part, if you see, previously independent criminal and terrorist groups alter their original aims and tactics and morph into single entity that exhibit the feature of both. So this is organized crime, the manner in which organized crimes are being committed. And the last section in this changes which I'm going to do today in the first part of the bahut deri ho raha hai, that is terrorist act. We will do it or will come and do it. So sir, we wait. ऐसे खाना. And in the last part, I will do crime against women and children. So in crime against women and children, इसमें एक चीज छूट गया है जो है snatching with it, snatching as a crime with it. Crime against women will do in the next of APPs. And there I was there in the board, one of the board, and the board kept on changing. So when the candidate came for the interview, we had only a code number, name and everything was not disclosed to us. And we were given a set of laws from where we could have asked them questions. So very transparent system of recruitment. Even the board members are not knowing the name and the title and the caste and the institution from which he has passed. So we were not supposed to ask them also. So only asking question and giving them marks. And in every board there was one DPP. So they have quite a few number of DPP. So they were there in each of the boards as a representative of the. No, but the recruitment process in our state is not that foolproof. There is only one board, and the board members have the entire file, which should not be there. If we want to recruit someone genuine candidate who is capable of getting the job, then in that case, the identity of the person should not be disclosed, because we are going to see the personality test. What marks they have got in written will be calculated after giving an average marks by the board members, and then they will be selected. So I think that transparency was very good. Okay, so can we start? All of इसको रख देते हैं, तो बंद कर दीजिए. So for the lunch, when we went, we were left. This is the offense which we were doing, terrorist act, and this is defined under section 113, subsection 1. Now, terrorism prior to this was dealt with by a specialized agency, as we all know, NIA, for investigation. And they had special prosecutors also to actually prosecute the cases under UAPA. And terrorist activities were considered to be an unlawful activity under the Unlawful Activities Prevention of Unlawful Activities Act. So Unlawful Activities Prevention Act, UAPA, was the law. Now here we have actually taken the definition from UAPA and copy pasted in this law. So it is exact replica of the UAPA definition. That is section 3 of the UAPA Act. So whoever does any act with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security or economic security of India, or with intent to strike the terror or likely to strike terror in the people or any section of people in India or in any foreign country. So the jurisdiction is not only India, also foreign country. So it has been widened very much. We will have to wait and see how much we are being able to actually look into these cases of the foreign countries. Now, in the first part, we are talking about the act. Now, how the act is committed is given in the other sub-clauses A, and what we find, A talks about by using bomb, dynamite or other explosive substance or inflammable substance or firearms or other lethal weapon or poisonous or noxious gases or other chemical or by any other substance, whether biological, radioactive, nuclear or otherwise, of a hazardous nature or by any other means of which whatever nature to cause or likely to cause. Again further, death or injury to any person or persons. So it can be one person or it can be more than one person. Or loss or damage to or destruction of property, or disruption of any supplies or services essential to life of the community in India or in any foreign country. So you can imagine it can be water supplies, it can be electric supplies, it can be internet supply, it can be any other kind of power supplies. So everything is inclusive here. Damage to the monetary stability of India by way of production or smuggling or circulation of counterfeit Indian paper currency, coin or any other materials, or damage or destruction of any property in India or in a foreign country used or intended to be used for the defense of India or in connection with any other purpose of the government of India, any state government or any of their agencies. So not only central government, also state government and their agencies as well. So overawes by means of criminal force or to show of criminal force or attempts to do so or cause death of any public functionary or attempts to cause death of any public functionary or detains, kidnaps, abducts any person and threatening to kill or injure such person or does any other act in order to compel the government of India, any state government or the government of foreign country or an international or intergovernmental organization or any other person to do so or abstain from doing any act, commit a terrorist act. So you can see it is such a wide, inclusive definition. Any act, any criminal force, any unlawful activity will be covered within the definition and meaning of terrorist activity. So this is an offense mentioned herein, and here only you will find that we are having further, lot of explanation as to what is public functionary, what is counterfeiting Indian currency, and in subsection 2 we are having punishment. So subsection 2 of 113 lays down punishment. If such offense has resulted in death of any person, be punished with death or imprisonment for life and shall also be liable to fine. Then in any other case, be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to fine. So minimum mandatory 5 years can go to the extent of life imprisonment and shall also be liable to fine. And subsection 3 talks about if it is conspiracy. Whoever conspires or attempts to commit or advocates, abets, advises or cites directly or knowingly facilitates the commission of terrorist act or any act preparatory to the commission of terrorist act shall be punished with imprisonment for a term which shall not be less than 5 years, which may extend to imprisonment for life and shall also be liable to fine. So what we find is that we have made the punishment very elaborate according to the degree, and it starts from subsection 3, 4, 5, 6, 7. So we are having 5 categories of punishment for terrorism of different types. So for conspiracy, for attempt, abetment, we are having 1 category. If it is an organized crime along with terrorist activity, then the punishment is again minimum mandatory 5 years, can go to the extent of life and also liable for fine. And if the person is a member of an organization, terrorist organization, shall be punished for imprisonment of a term which is for life and shall also be liable to fine. There is no minimum mandatory but life imprisonment. And if anyone is harboring or concealing knowingly, say if I talk about who will come under the 7th category, is null in his case. Nalini did not actively participate in the terrorist activity of an assassination of the Prime Minister, but what she did, she actually took Dhannu every day, 1 month, to the spot, practicing. First, they both used to go to the temple, then from the temple they used to go to the spot, and she would be made to sit there. Dhannu would be made to sit there, and Nalini was accompanying. So she did not actively participate, but she supported terrorist, human bomb. So that category will be taken care of under section 7. So variety range of punishments they are given there, 5 types. So this is the new changes. Till now we have done the new changes, and here there are few offenses like this is sedation. Sedation word is not used, but we are actually defining sedation exactly what was there in 120A here in 150. So that is there, but only the word sedation we are not using. But the verbatimly it means same, and it is more wider, you can say, because the whole chapter deals with in detail. This I have already done as a community service as an offense. The snatching as an offense is again another change. That is 304 in theft only. We subsection 2. Snatching is subsection 1 and 2. Theft becomes snatching. In order to commit theft, the offender suddenly or quickly, forcibly seizes or secures or grabs or takes away from any person or from his possession any movable property. And punishment for the snatching is given under subsection 2. That is, whoever commits snatching shall be punished with imprisonment of either description for a term which may extend to 3 years. So this is the theft punishment only. But we have actually defined snatching separately, and snatching as an offense has increased. NCRB report also shows. So that is why a separate category of mentioning it is there, but punishment is the same of theft. Now coming to crime against women. Here in the new law, we have consolidated. We have consolidated the entire chapter 5 of the Bharatiya Nyaya Sanhita and titled it as Crime Against Women and Children. So this chapter, if I talk about, starts from section 63 and ends under section 99. So from 66 to 99 is the entire chapter of crime against women and children. Now, if I talk about definition of rape, rape is defined under section 63 now. So 375 has become section 63. There is no change except in the explanation clause. In the explanation clause, you will find that we are in section 63, the husband used to get a leeway under exception 2. Exception 2. Sexual intercourse or sexual act by man with his own wife, and wife not being, here we are using the word 18 years. So this is independent thought judgment has been actually replicated in this particular explanation. So a child is a child under POCSO law, and wife is also a child under POCSO law. Inclusively, child is a wife under the rape definition as well, if women has not completed 18 years of age. So if it is less than 18, then in that case it would be rape. Husband would be charged of rape. Now punishment section remains same. Punishment is given under section 64. And in 64, 376 subsection 1, how it was there, 10 years minimum mandatory, can go to the extent of life imprisonment. So it remains same. If I read verbatimly, whoever, except the cases provided in subsection 2, commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. So this remains same. Now in subsection 2, all those custodial rape, which was earlier also there, from A to M. A to M remains same, no change. Punishment also remains same, no change. If I read the punishment, shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which, so minimum mandatory 10 years, can go to the extent of life, and here life would mean whole natural life. Life imprisonment would mean whole natural life, and whole natural life and shall also be liable to fine. Now here question comes in, will this sentence be not permitted for commutation?
No.
Remission, suspension?
No.
It's only natural life.
What about remission?
It's not applicable if the offense is
And what about suspension? During the period of appeal, suspension will be enough, not beyond that. So armed forces are explained as it was earlier explained, hospital, police officer, women and children institution. These were also explained earlier. Here also this explanation remains same. Now, if you remember in 2018, in subsection 3 was added to section 376. Remember 3? So now that has been picked up and put under section 65. Okay, so 65 has 2 subsections. And here it talks about punishment for rape in certain cases. So section 64 has 2 subsections. First subsection talks about if whoever commits rape on a woman under 16 years of age and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years. So here minimum mandatory punishment 20 years, but which may extend to imprisonment for life. Life shall mean whole remaining natural life with fine. Now there is proviso. 2 provisos were there in subsection 3. Those 2 provisos are here. Provided that such fine shall be just and reasonable to meet with the medical expenses and rehabilitation of the victim. This is first proviso. Second proviso says that further the fine imposed under subsection shall be paid to the victim. So it has to be collected from the wrongdoer's pocket and paid to the victim, and it is for the medical expenses and rehabilitation of the victim. Now in subsection 2, it talks about rape of a woman under 12 years of age. So this 12 years of age was 376 AB. AB is now subsection 2 under section 65. So whoever commits rape on a woman under 12 years of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life imprisonment, which shall mean imprisonment for the remainder of the person's natural life, and shall also be liable to fine or death penalty. So this is a first offense where death penalty is still retained in the rape law. This was already there in AB. Now we have actually put it under section 65 subsection 2. And those 2 provisos of medical expenses and rehabilitation, fine has to be collected, and the second proviso that fine has to be paid to the victim, that is remains same. Now in 66, we have retained section 376A, capital A, vegetative state. Vegetative state 376 capital A था, उसको भी यहाँ पे we are retained in 66. Everything remains same, inclusive of death penalty. So this is the second offense under rape where we are giving death penalty, vegetative state. Now husband during judicial separation, that clause was there under 376B. हाँ, बी अब हो गया है सेक्शन 67, sexual intercourse by husband upon his wife during separation. The wordings and the punishment remain same. Now, shall not be less than 2 years, but which may extend to 7 years, and shall also be liable to fine. तो ये पहले भी था, अभी भी same remain. Coming down to section 68, this is sexual intercourse by person in authority. तो C और वो सब था ना, C और वो सारा यहाँ पे, हाँ, तो C में है, that also remains same. And as we all know, definition of public servant पहले था IPC में 221, so 221 is now 228. Public servant same, कोई comma full stop has or not changed, but the number has changed from 21, it has become 228. 21, there is, I'll check and tell you. Only 21. 121 has now become 28. No, 28. मैंने section 2 subsection 28. समझ में आया? मैं 228 बोल रही हूँ, तो 228 नहीं, 2 clause 28. और वो जो सर पूछे ना, तो 21 क्या हो गया, उसको भी बता देते हैं. 21 क्या हो गया? पहले था, अभी 21 इज मूवेबल प्रॉपर्टी. मूवेबल प्रॉपर्टी पहले था 22, अब वो 21 हो गया. हाँ, नहीं, जनरल एक्सप्लेनेशन का कुछ 3 में भी है, 3 में भी कुछ है. जैसे फॉर एग्जाम्पल 3 में है आपका डेफिनेशन ऑफ कोड टू बी अंडरस्टूड एज एक्सेप्शन, और सेंस ऑफ एक्सप्रेशन वंस एक्सप्लेन, वो सब है. और भी सारा कई सारा है 3 में. 3 में है आपका जनरल एक्सप्लेनेशन, आपका क्या कहते हैं, जनरल एक्सप्लेनेशन में एक्ट डन इन फर्दरेंस ऑफ कॉमन इंटेंशन. 34 था, वो अभी यहाँ पे 3-5 हो गया. तो 3 का सब क्लॉज काफी सारा हो गया, 7, 8, 9 सब क्लॉजेस हो गए हैं. तो वो मतलब काफी चेंजेस है, मतलब खाली सेक्शन चेंजेस, वर्ड सेम, कॉमा फुल स्टॉप आल्सो सेम. सो मैक्यूलो का कुछ भी हैज नॉट बीन चेंज्ड. ओके, सो कमिंग डाउन टू दिस सेक्शन दैट इज हस्बैंड हो गया, बाय अथॉरिटी हो गया, और 69 ये नया है. फॉल्स प्रॉमिस ऑफ मैरिज का बहुत सारा केसेस होता था. हाँ, अगर फॉल्स प्रॉमिस ऑफ मैरिज का आपको ज्यादा देखना है तो आई वुड रिकमेंड लेक्सिस नेक्सिस पब्लिकेशन, क्रिमिनल लॉ बाय KI विभूति. पुराना अच्युतन पिल्लई वाला बुक को उन्होंने रिवाइज किया था. प्रिंसिपल रिमेन सेम. होल 1 chapter is there on false promise of marriage in the rape chapter. So you can look into that book, is very good book. I told sir कब नया बुक ला रहे हैं, न्याय संहिता का? So he is saying that I'm working on it, wait for some time. So he will come up with a new book on Sanhita also. But the old book, if you buy, I think when the discounted rate you will get now, and that will be very useful.
68 by person in authority is also mentioned in section 65. Person in authority. The distinction, that is the distinction. Person in authority.
इसमें ना compromising है, क्विड प्रो क्यो, कुछ दे के कुछ पाना. उसको पहले वाले में कुछ दे के कुछ पाना नहीं है. 376 का सबसेक्शन 2 में जो अथॉरिटी पर्सन है, देयर दैट इज नॉट गिव एंड टेक, फोर्स. हियर देयर इज नो फोर्स. देयर मे बी women willingly doing it for something she gets in return. So that is why you see we have different category here.
No, madam, person in authority like jail authority.
हाँ, jail authority.
Here is also 68.
हाँ, so the difference.
There is a repetition.
नहीं सर, रिपीटेशन नहीं है.
Madam,
नहीं, हम लोग that is why that book I am telling that sir you read that book, very nicely explained. नहीं, सही बोल रहे हैं आप. और इन दोनों सेक्शन में what is the difference? The difference is that women in these situation negotiated. ठीक है, कुछ पाने के लिए कुछ, तो गिव एंड टेक. हाँ, अंडर द कौन. हाँ, नहीं ठीक है, आप बोलिए ना.
मैडम
तो मेरा भी कुछ सीखना होगा सर, बता दीजिए।
मैडम डायरेक्ट थोड़ा काइंडली
दिखाओ। हाँ, एक मिनट सर। Actually, no, sir. When the case will be under this section 68, or when it will be there? 64 का subsection 2 में. When it will fall? Those cases where there is no give and take, that automatically comes. Highest punishment है ना, minimum 20 years, can go to the extent of life, and life would mean whole natural life. Subsection 2 का हमने वही punishment किया है. So here, in the next category, the punishment is less. कितना सेक्शन बोले हम लोग?
65, 68.
पहले हम लोग 64 देखते हैं पहले। 64 है ना? 64 ही है ना सर यहाँ पे? हॉस्पिटल, आर्म फोर्सेस, पुलिस फोर्स, 64 है। हाँ, 64(2), जो कि 376 का 2 था, है ना?
There was also authority, here is the authority.
हाँ, ये सब अथॉरिटी है ना। ये जो 2 है, इसमें जो अथॉरिटी है, इसका पनिशमेंट क्या है देखिए। मिनिमम मैंडेटरी 10 years कैन गो टू द एक्सटेंट ऑफ लाइफ, एंड लाइफ वुड मीन होल नेचुरल लाइफ। ये देखिए। और अभी हम लोग देखते हैं हमारा ये जो नेक्स्ट सेक्शन है, अथॉरिटी। हाँ, मिनिमम मैंडेटरी 5 years कैन गो टू द एक्सटेंट ऑफ 10 years and shall also be liable to fine. तो जज कब ये लेस पनिशमेंट देगा, आप बताइए।
No, I am telling about repetition of the words regarding authority.
हाँ, that is repetition is there.
That's
But how a judge is going to differentiate between the two cases?
Which favors the accused? The law says.
No,
you
no,
cannot favors
sir.
the accused.
Which category of cases?
The only difference between 68 and that earlier, such only one word, ma'am. Such sexual intercourse not amounting to the offense of rape.
हाँ, so कब रेप होगा? तब इसका मतलब कंसेंसुअल था,
वहां पर नहीं है।
वही मैं एक्सप्लेन करना चाह रही हूँ।
Only difference.
अगर मान लीजिए उसमें कंसेंट नहीं था, women says no consent, court is going to believe no consent. इसमें women का consent है, लेकिन in a compromising situation in by the authorities. So there is quid pro quo situation. ठीक है? आप इसका एक्सप्लेनेशन वहीं पे आपको मिले। Got it all of you? सर, आप समझ में आया? नहीं आया? आप उनको साथ साथ बैठ पर बैठ जाइए। हाँ, कंसेंट है, इसमें कंसेंट नहीं है। हाँ, तो पनिशमेंट भी हम देख लिए। मिनिमम मैंडेटरी 5 years कैन गो टू द एक्सटेंट ऑफ 10 years एंड शैल आल्सो बी लायबल टू फाइन। और वहां पे मिनिमम 10 कैन गो टू द एक्सटेंट ऑफ लाइफ, एंड लाइफ वुड मीन होल नेचुरल लाइफ, मतलब विदाउट रेमिशन, विदाउट कम्यूटेशन ऑफ सेंटेंस। यहाँ पे भी एक्सप्लेनेशन सेम है। इसके बाद है ये फॉल्स प्रॉमिस ऑफ मैरिज। False promise of marriage, a separate category, new offense. That is why I have highlighted with red color. This is a new offense, not there in IPC. Now here you will find whoever by deceitful means or by making a promise to marry, वहीं पे दिखा लेती हूँ, वो खुला है। आप लोगों को दिख रहा है ना? ये देखिए, और थोड़ा बड़ा करने से अच्छा होता क्या? ये बड़ा नहीं है। दिख रहा है क्या आप लोग को? 69 हाईलाइट कर देती हूँ।
10 years punishment.
हाँ विच तो मैक्सिमम 10 years। उसमें भी आप देखेंगे सर कि कंसेंट था, लेकिन कंसेंट किस लिए था? मैरिज के लिए, कि मैरिज वुड सब्सिक्वेंटली टेक प्लेस। सो बिकॉज इट इज कंसेंसुअल एंड मैरिज डिड नॉट टेक प्लेस, पनिशमेंट देखिए कम है। ठीक है। सो deceitful means by making promise to marry to a woman without any intention of fulfilling the same, has sexual intercourse with her. Such sexual intercourse not amounting to the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. And there is an explanation for the deceitful means as well, shall include inducement for or false promise of employment, promotion, or to marry by suppressing identity. So you can imagine all those human trafficking cases where enticement is for job, better placement, all will come under in this case false promise. Sexual intercourse by employing deceitful means, not only false promise of marriage. Okay, and etc. Deceitful means and etc. So all these categories are taken care of, coming under this umbrella. Or 70 is gang rape. Now gang rape of a girl below 12 years, below 16 years, all covered here. Okay, so this section has 70 has 2 subsection. Earlier gang rape was there in 2 sections, 376 D or DA and DB, 3 sections. तो अब हो गया है clubbed in 1 section. 70 talks about where a woman is raped. आपको दिखाई दे रहा है यहाँ पे, देखिए 70 पूरा, थोड़ा ऊपर कर देती हूँ. Where a woman is raped by one or more person constituting a group or acting in furtherance of common intention, each of those persons shall be deemed to have committed the offense of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which will mean imprisonment for remainder of the person's natural life with fine. Now there are 2 provisos there. Proviso such as fine shall be just and reasonable to meet with the medical expenses and rehabilitation of the victim, provided further that any fine imposed under this subsection shall be paid to the victim. So these 2 provisos were there earlier also. Now also it remains the same. Subsection 2, where a woman under 18 years of age is raped by one or more person constituting a group or acting in furtherance of common intention, each of those persons shall deemed to have committed the offense of rape and shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of the person's natural life with fine or with death penalty. This was earlier there. Now also we have retained death penalty. और ये आप देखिए, this is the 4th offense under rape chapter where we are giving death penalty. ठीक है? और 2 proviso remain same, provided that such fine shall be just and reasonable to meet with the medical expenses and the rehabilitation of the victim, and provided further that any fine imposed under this subsection shall be paid to the victim. Or last section in this category of rape is repeat offense. Repeat offense में भी आप देखेंगे death penalty. तो इसको मिला के actually 4 हुआ, 4 offense, total 4. So total 4 offense we are giving death penalty for rape. That is punishment for repeat offense. और इसमें रिपीट ऑफेंस के सेक्शंस हम लोग मेंशन कर दिए 65, 64, 66 and 70. If the offense is under these 4 sections, repeat, then there will be minimum 20 years, can go to the extent of life imprisonment, and life would mean natural life. ओ यहाँ पे 20 years नहीं है, यहाँ लाइफ इम्प्रिजनमेंट ही है, सॉरी यहाँ पे लाइफ इम्प्रिजनमेंट ही है, और लाइफ इम्प्रिजनमेंट मीन्स होल नेचुरल लाइफ.
Group, suppose a woman is in a group, so can she be prosecuted for gang rape?
So there is one wrong erroneous judgment by Priya Patil, known as Priya Patil. उसमें बोला था कि women cannot commit abetment of rape. That is an erroneous judgment. उसमें उसका फैक्ट था कि हस्बैंड ने डोमेस्टिक हेल्प को रेप किया, कुछ गलती की थी, और वाइफ ने बाहर से दरवाजा बंद कर दिया. That so that she cannot escape. But here the act of the women was abetting the crime of rape. So according to me, the act of women would also be, abetment does not talk about men and women. So that judgment is an erroneous one. Women can abet the crime of rape. No harm. और पॉक्सो में तो हम लोग women को लाइबल भी करते हैं, है ना? दादी माँ तब सुनवाल का केस है, तो बच्ची को, छोटा बच्ची को कौन दिखा रही थी, फोर्स करती थी देखते. So then in that case mother complained and a case was registered, investigation was done. So this is offense under POCSO. Now showing porn to children is an offense. तो अभी जैसे अबेटमेंट वाला बोल रहा है, अबेटमेंट को
Gang rape?
भी होगा ना, जो ऑफेंस के लिए हुआ है, जो भी ऑफेंस के लिए हुआ, women can be made that as an abetter if she has actively participated. क्योंकि यहाँ पे हमको common intention चाहिए, acting in furtherance of common intention. So if she is acting in furtherance of common intention, she would be liable. Okay. So this is there. अच्छा, section 228 capital A था, आपको याद है? Section 228 capital A was introduced in the year 1983 criminal law amendment. क्या था वो? Identity disclose करना. हाँ, वो section को यहाँ change करके 72 कर. So 72 is disclosure of the identity of a victim of certain offences, और इसको बहुत elaborate, they have actually elaborated the law, completely detailed. In that 228 capital A, only one clause was there, one para. Now here in this offense we are having two paras. And this has been widened, scope has been widened, and that is the change. Change क्या है? Whoever prints, publishes the name of any matter or which may make known the identity of any person against whom the offense under section 64, 65, 66, 67, 68, 69, 70 or 71 is alleged or found to have been committed, thereafter this section referred to as victim shall be punished with imprisonment of either description which may extend to 2 years and shall also be liable to fine. ये सेम है, ये कोई चेंज नहीं है, नया सेक्शन का नंबर यहाँ पे नया डाला है. In subsection 2, exceptions are given. Exception to subsection 1. So nothing in this section will extend to any printing or publication of the names or any matter which may be known the identity of the victim if such printing or publication is by or under order in writing of the officer in charge of the police station or the police officer making investigation into such offense acting in good faith for the purpose of such investigation. कौन सारे cases आएंगे? Missing person, girl is missing and girl is not been found, or a complaint of human trafficking has been registered. Then you publish it in TV, radio. Otherwise, how will you get? So that publication will not come under first category. Second situation, by or with authorization in writing of the victim. If you see in Sandesh Khali case, TV mein the women came out in open public, victim themselves complaining about the crime. If she is coming orally or in writing, खुद के अगर विक्टिम ही वो इंटरव्यू देगी चाहे टीवी चैनल्स में, तो आप क्या कर सकते हैं? एक्सेप्शन. एंड थर्ड इज where a victim is dead or child of unsound mind or with the authorization in writing of the next of kin to the victim. तो उसके पेरेंट्स ने उसके लिए ये किया. Now provided that no such authorization shall be given by next of kin to anybody other than the chairman or the secretary by whatever name called of any recognized welfare institution or organization. यहाँ पे एक एक्सप्लेनेशन भी है, आप देखिए. For the purpose of this subsection, recognized welfare institution or organization means social welfare institution or organization recognized in this behalf by the central government or state government. यहाँ पे you can note down there is one judgment by Calcutta High Court, Prafulla Mura versus State of West Bengal. In POXO cases, the name and identity of the victim cannot be there, including FIR and charge sheet. So name has to be written in an envelope, sealed it. Name and address has to be written put it inside an envelope, seal the envelope along with the charge sheet. That will be opened by the court taking cognizance. So this is how directions have been given to all the police station in Bengal for non-disclosure of identity of the victim in POXO cases, which they are following in all kind of rape cases also of a women under 18 years of age. Okay. Not to disclose, but how it has to be disclosed was laid down by Justice Bagchi in this judgment. A writ petition number है, a criminal appeal number है DB 2005. It was decided on 18/4/2022. So ये actually is available in livelaw.com. तो आप देख सकते हैं वहां से. Okay. So this is relating to the crime of rape. There are many other offences which were there earlier also, which has changed address only. No major change is there. Newly introduced offences are not there, but they are changes. जैसे section का number ही change हुआ है. If you see, it is assault or criminal force. अगर हम दिखाएंगे आपको, assault and criminal force is now 74. For outraging modesty, which was 354. 354 has now become 74. And sexual harassment has become 75, which was 354A. And assault to disrobe is 76. Voyeurism is 77. Stalking is 78. And words, gesture and act intended to insult modesty of a woman is 79. जो कि पहले वो था आपका 506 और 509 था ना. हाँ, वो सब इधर आ गया. ठीक है, एक जगह पे क्लब कर दिया. नहीं, उसमें तो ABCD था ना, वो तो ऑलरेडी है. हाँ, वो ऑलरेडी है. उसके बाद डाउरी डेथ आ गया है सेक्शन 80 में. हाँ, 304B. हाँ, और ये cohabitation caused by a man deceitfully inducing belief to the lawful marriage, ये 81. हाँ, 498. 493. और marrying during the lifetime of a husband जो था bigamy. हाँ, bigamy 82 हो गया. बाइगैमी जो था 494, वो अब हो गया है 82. सो ये सिर्फ घर का सिर्फ एड्रेस चेंज किया है. और मैरिज सेरेमनी फॉर फ्रॉडुलेंटली अंडरगोन विदाउट लॉफुल मैरिज इज 83. एंटाइसिंग और टेकिंग अवे women detained with criminal intent to married women 84. Also marriage against crime against institution. Institution means marriage as an institution. So all these have been clubbed in one place. So 85 है husband or relative of husband, subjecting women to cruelty. So 498 capital A is now section 85. And cruelty is defined, cruelty was defined under 498A explanation. उसको यहाँ पे अलग कर दिया है 86. Okay, so this is a new change. And kidnapping, abduction, inducing a woman to compel her to marriage is 87. और यहाँ पे causing miscarriage 88, ये पहले भी था. Causing miscarriage without consent 89. Death caused by act will intend to cause miscarriage 90. All these offences remain same. और यहाँ से लेकर के from 93 we are having offences against children. So offence against children is exposure and abandonment of child under 12 years of age by parents or persons having care of it. This, juvenile justice care and protection had the provision for punishment. Now it is here also. And concealment of birth by secret disposal of dead body. So ye hai 94. Hiring, employing or engaging child to commit offense 95. इसमें pornography भी आता है. And procreation of children 96. Kidnapping or abducting child under 10 years of age with intent to steal from its person 97. Or selling child for the purpose of prostitution 98. And buying child for the purpose of prostitution 99. तो ये ह्यूमन ट्रैफिकिंग के केसेस भी यहाँ कवर्ड हो जाते हैं. So this chapter is crime against women, and we are having all these sections in one under one roof. जो अलग अलग जगह पे था 361 और 364, 363. All these have been clubbed in one place. So by this I complete, and now you can ask me question. These two are the law and the PPT is here. You can actually ask me any questions if you want. Where is the class? Online people. I can't see them. Huh? Oh. So any questions I can take up now. Thank you all for patiently listening, and we had some discussion. Now more discussions will be in later class when you will do the work in the field and find difficulties. Otherwise going through verbatimly, that way you are hardly having much query. When you will face difficulties, then there will be more query. And I think with procedural law query will be more.
Contact number, please.
My contact number is 9433610382. 33610382. मैं जब भी बोलती हूँ ना कि 18 साल में पाँव दिया 365 डेज चाइल्ड वाला, लोग बिलीव नहीं करते. मेरा प्रिंसिपल मैजिस्ट्रेट हो या फर्स्ट ऑफिस सेकंड ऑफिसर ऑफ एवरी पुलिस स्टेशन, जुवेनाइल पुलिस ऑफिसर, पहले तो उनको समझ में ही नहीं आता कि जीरो में तो हम लोग जीरो बर्थडे नहीं मनाते हैं ना. पहला बर्थडे कब मनाते हैं? आफ्टर 1 ईयर. तो 18 में पाँव दे करके हम लोग कैसे 18 साल के हो गए? If you step into 18, live for say 365 days before the midnight, you will complete 18 years. मेरे हस्बैंड भी जज है, उनसे भी बहस होता रहता है. वो भी बोलते कि क्या तुम्हारा कैलकुलेशन गलत है. बोले कि मैं बता रही हूँ ना, मेरा नहीं है, सुप्रीम कोर्ट ने करके दिया.
सर करके बताना पड़ेगा 18 into 365 days
18 प्लस
नहीं, हम जो बोलते हैं उसको जब समझने के लिए
हाँ वो
18 into 365 days
एक्चुअली एक स्टीरियोटाइप अंडरस्टैंडिंग रहता है ना, और उसका तो प्रति बायसनेस रहता है. क्योंकि पहले आप देखेंगे 2000 वाला लॉ में था अंडर 18 years, एंड देयर वाज सो मच ऑफ कंफ्यूजन, सो मेनी केसेस केम बिफोर द कोर्ट. And then finally it was decided that we should use appropriate word is completed, not under. Completion. So now the Nyaya Sanhita also, when it was drafted, They should have copy pasted the juvenile justice का definition of child to make it parity. अभी आप देखिए 18 साल के पहले शादी नहीं कर सकते और यहाँ पे 16 साल के ऊपर में कंसेंट दे सकते हैं, पनिशमेंट कम हो जाता है 16 साल के ऊपर कंसेंसुअल होने से. So this is all age game, no? Everywhere at par with we should have done 18 years. Gang rape of 16 years of girl. Why? Put it 18. Death penalty record minimum 20 years. What is the harm? Is there any harm? Let the judge then decide कि कुछ consent था नहीं था, because judge has lot of discretion. हाँ. No, sir, then what I am saying, keep parity at 18. If you keep parity at 18, there will be no age game. Kidnapping, abduction, children का सब का जो भी offense है 18 years रखो. 16 साल 18 साल करने का कोई जरूरत नहीं. If you create 16, 18, this confusion will be there and defense will play with it. Defense will play with it. So why to leave scope for defense to play? That is my understanding. And if we really want to punish, अभी जैसे हमने juvenile justice में change किया है ना, there are studies done by doctors and psychologists and psychiatrists that the development of the brain from 14 to 18 also it does not stop. It completes by the age of 21. So the brain is developing and the body is also developing. The hormonal changes are taking place up to the age of 21. So in that case, if we really want to see that our children who indulge in such kind of activity, ये आपका Romeo Juliet cases, you will find that we will not be punishing. We should actually think about increasing to 21. There are a lot of studies worldwide, not only in India, worldwide. So if really we are concerned about our children and we want to give them a scope to reform and rehabilitate, then actually it should be 21. Why we are playing at 18? So this is my understanding. लेकिन आप देखिए ना, जुवेनाइल बोर्ड में केस भरे हुए हैं, चिल्ड्रन कोर्ट में केस भरे हुए हैं, और पॉक्सो के केसेस चिल्ड्रन के अगेंस्ट में ज्यादा है. 90% केस. एक तो पुलिस ऑफिसर का क्या हुआ ना कि one girl, women complained that the boy promised for marriage and did not marry, had sexual intercourse, so charged that boy for rape. When the police officer started investigating, found that the boy is 16 years of age. मैंने borderline, not even completing 16 का under. अब बताइए, लड़की is case is made out against the women, not the boy, because in this case the girl is above 18 years of age. तो पॉक्सो का केस तो लड़की पे बन रहा है, लड़के के ऊपर 375(6) करने जा करके, और so these kind of cases are also there, and that officer comes and tells me what to do, man, because the FIR was lodged by the women. So then he started investigating. So मैंने कहा कि you come with clean hands with the court and disclose to the court, let the court decide. और क्या बोल सकते हैं बताइए, क्योंकि हमको तो रेमेडी उसको देना है जो FIR किया है. लेकिन उस FIR को जब हम इन्वेस्टिगेट करना शुरू किया, then I found that actually the boy is victim and not the accused. So these type of cases also are coming, which are in conflicting zone, overlapping conflict. So how to deal with that? And the law does not say anything on it. Does law say anything on it? The boy has a boy is still studying in school, so he is having a school certificate, and school certificate is considered to be the correct document. What's that? School certificate is considered to be the authentic certificate. In dispute, they are different. There may be 2-3 certificates, birth certificate, 2-3 birth certificate, or 2-3 school living certificate. School certificate. But ossification test is plus minus 2 years. So plus minus 2 years means he can be 18 years or he can be 14 years. No, but there is a Supreme Court judgment I'm forgetting now, where the Supreme Court said benefit of doubt will go in favor of the accused. So there, if he claims I am juvenile and he cannot establish or documents are conflicting, then benefit of doubt will go in favor of accused. तो हो गया काम खत्म. हमारे पास तो कुछ है नहीं बचा. और plea of juvenile can be taken in any stage. तो सुप्रीम कोर्ट में जाके भी हम बोल सकते हैं कि हम जुवेनाइल थे when the crime was committed. So this is there. Okay.
Madam,
Thank you,
what is the status of section 90 of IPC, where the consent are known to be given under fear of
हाँ उसका भी चेंज वो सेम ही है सर. कंसेंट रिमेन सेम, सेक्शन का चेंज हो गया है. सेक्शन इज नाउ
misconception type that section 90. That's very important for us.
Section 90 is now, I'm telling you, 1 minute. 90 is 28. Consent known to be given under fear of misconception. This is now section is changed. Wording remains same. 28. आपका वो अनसाउंडनेस ऑफ माइंड जो 84 था वो 22 है. चाइल्ड अंडर 12 years 7 years and 12 years जो डॉली कैपैक्स is now 21. डॉली इनकैपैक्स is 20. तो ये सब चेंज हुआ. एक्सीडेंट is 18. पूरा चैप्टर में खाली सेक्शन का चेंज है, बाकी इसमें कुछ चेंज नहीं है. चैप्टर हैज चेंज. मेरा पेन ड्राइव निकाल दो. एनीथिंग एल्स? अब आप लोगों को कैप्सूल ट्रेनिंग का होगा, एक एक चैप्टर के साथ तब होगा. लेकिन मुझे लगता नहीं है जरूरत है, क्योंकि आप लोगों को तो मर्डर का चैप्टर तो पता ही है, उसमें तो कोई ज्यादा चेंज नहीं है. अच्छा हाँ नहीं हाँ सर, उसमें जैसे 28 जो है, इट टॉक्स अबाउट 12 years बिलो इज नो कंसेंट. और यहाँ पे 12 years बिलो का तो अगर रेप है तो वी आर हैविंग दैट पेनल्टी. और उसके बाद में अगर 16 साल का है तो फिर हमारा हायर पनिशमेंट. सो इन दैट वे कंसेंट दिस दैट इज व्हाट आई एम सेइंग ना. सब में 18 साल का नीचे करना चाहिए. It should be one who has not completed 18 years. That should not have been there at all. So, POXO will increase, sir. POXO will increase. There is a lot of misuse of POXO. And you at the very beginning, you cannot make out there is misuse. So how are you going to deal?
Police are helping. As there is no sexual assault, so POXO is not implicated.
नहीं, तो आपको मैं एक बताती हूँ. कलकत्ता हाई कोर्ट का जजमेंट है. अगेन आई कंसिडर दिस जजमेंट एज एन इरोनियस जजमेंट. वो क्या किया है कि व्हेन द गर्ल वाज गोइंग, फ्यू बॉयज पुल्ड हर दुपट्टा, तो पॉक्सो केस कर दिया. ये पॉक्सो केस सिंपल असॉल्ट होना चाहिए था. It is outraging her modesty. Dupatta is considered to be parda. ठीक है. Judge actually in High Court acquitted him. Actually, judge should not have acquitted him. Judge should have sent it back to for investigation under 354. That should have been the right position. तो जज साहब से मैंने बोला कि सर आपने क्या सही किया, अब बताइए तो। जितने मन चले लड़के हैं उस जजमेंट को देख के तो सब एक्विटल पाने के लिए उनका तो मन बढ़ जाएगा। हाँ, there is no such awareness. Otherwise, people would have started. And there is so much of eve-teasing and harassing of women in small locality pockets. You will find there are people. So there are so many deaths also in Bengal. Father wanted to stop eve-teasing, brother wanted to stop eve-teasing, father and brother was lynched to death. So that is there in case. These cases are also there. So when the judge is passing a judgment, he should be cautious enough what impact it would have in the society. Message to the society. I agree that this was maybe not a fit case under POCSO, but you could have sent it to the concerned police station for fresh investigation under 354 and a charge sheet under 354 could have been made. That is why in police training, I always tell, put all the section. My student, when he teaches, he says, no, highest punishment section only you put. I say, no, you also put outraging modesty. You also put 509, 506, so that, some punishment wrongdoer will get. And
both sections the police have submitted charge.
No, but there are some cases where they miss. Like in one of the training, I came to know that the person who was actually filing charge sheet, he was doing it for first time under POCSO, and he did not make the judge who took the 164 statement a witness. He did not make the doctor who did the medical examination a witness. So ये सब तो erroneous है ना. तब he said in the training he did not tell me. He came back of me after completion. मैंने कहा कि सर आपको तो पूछना चाहिए था अपना superior officer को, and superior officer should have also seen the charge sheet because his signature is required to be placed before the court. The officer in charge signature is required in the charge sheet. He also did not see. मतलब बहुत साइन करना पड़ता है, लेकिन न्यू कमर का चार्ज शीट तो एक बार पलटाना पड़ता है ना, देखना चाहिए कि मेरा न्यू कमर. But they should see ना. So I said कि अब क्या remedy है, put in a supplementary charge. What can you do otherwise? So you have to keep a scope in the charge sheet that the charge sheet has not been completed because of want of report, medical report, forensic report. So there are some scope there. So in that case, you put it along with this, all the remaining supplementary charge sheet can be taken care. So this is there. Our police officers are also, the newcomers are like little erroneous. So we will have to wait and see what will be the results. Okay, sir, all of you taken enough time. Lot of discussion. Maybe I went very fast. New law. I am also learning. ठीक है सर. हमारा ये क्लास कब तक है?
So that it will be helpful for us. Hello. Good afternoon to everybody. So I think you are refreshed with the tea, I think. So we will now discuss about two factors. One is the scene of crime focus, and second thing is the digital evidence integrity. These two we will discuss. So I will go a little bit faster. Most of the things are not related to you. I will skip those things which are irrelevant to you. Those things only I will try to discuss it. इसका काम So basically, when the investigation starts, for any case, basically what it is received by the IO, what basically he receives. Reason yesterday we have confusion, conflict regarding the 3 days FIR and all those things. So if we are getting clear the concepts of this, then we can able to move further. Okay, so please answer me. Whenever anything happen, so what the IO used to get it? चाय पीने के बाद भी नींद आ रहा है क्या? What he will get? What he tried to do? What he will get it? No answer. Don't like to answer. No, whenever something gone wrong, what he will get? First IO, what he will get? He will go to spot. Okay. And then anything?
He has to examine that person.
He has to examine that person. Try to ascertain. So what is those are all? What is those are all? उसने कोई आके बोला. What is that? It is an evidence. It is an information. Very good. So normally, basically, IO, whenever if something goes wrong, he will get the information. That is the most important. But whatever the information he gets, it is a true or false. How he will realize? He is not a god. That if you do investigation also, what you will get it? Again the information only. It is a bulk of information only. So those are all information true. How you believe it? That is my question. I think you have made it clear, I think. He is getting number of informations one after the other. You go on digging, you will get so many information. Those informations are the true. How he will make true? That is the truth. If you proceed further, how much you may proceed? You will get much more information only. But all those informations are true. When he believes, when he confirms that true, that is information is the true. Spot also information only, na? That is not the truth. When those informations are convergent into one place, then that believes, that means that those informations are true. If the informations are divergent, then he can't make any conclusion. Those informations has to converge into one place. Then only he can believe that that information may be true. It isn't true, no one knows God, except God, if he is there. Okay, remaining all, it is the, so normally IO works on basis of the hypothesis. Reason is one, he make that means he has so many convergence informations are coming closer to one. Sometimes some information converge into one corner, some information converge into another corner. Then what he will say? he will make two hypotheses. If all converge into one place only, one hypothesis only. If he converge into 2-3 places, then he make three hypotheses, and he make the groups into 3 groups, and he investigation. That is the truth. So further that I wanted to communicate, that means how converted information into a truth. Okay. So reason is, okay, now if I say one example to you, if something 2,000 rupees are from missing in your pocket, what you will do in your house? Okay, you thought, okay, so your son has been taken away by the money. What you will do?
We'll ask the question.
Very good. Then afterwards, you verify it. Very good. Then afterwards, be comfortable. Talk something. Then what you will do? You stop there only. Okay, very good. You carry on. Take two more notes, daily two notes. That way you do.
I will ask for morning rebuke.
Huh?
To return back tomorrow. Should we book him to not should comment?
Not you may suggest is a good father. Okay, give the suggestion. Or some other father may call him and give the slap. Okay. So there, what we are doing, we are working as a complainant, victim, and investigating agency and prosecution. Maybe sometimes your wife is strong, she will fight. My son is better, good, and only he selected money for that other purpose. He works as a defense lawyer, and then you become a judge, and then you become a punishing authority also by slapping or counseling that person. So you are doing all the jobs by one person. But in the court, you are doing the same. Huh? No, you are not doing all the jobs. Your role is prosecution only, convincing the court. What the IO brought it, effectively putting those things in order and presenting those things to the court. So now, why my stress is that I will come to you, that is only. Okay, so what your role need to be? That means every time the investigating officer, sometimes prosecution wings, the overjumps to do, that means everything we are doing. So that overjump should not be there. Now, what is the difference between the information and the evidence? Is there any difference between information and evidence?
Yes.
What is that?
Yes. It's collected of court. When there's some collected of the instance by any officer.
So which can be placed in front of the court, that becomes an evidence. Okay, it is a legal terminology, what we say. Okay, complaint is different and FIR is a legal document, that is only. That is a legal document words. So evidence is divided into 2 groups. One is a direct and indirect, direct subject to indirect. So direct subject to, it is the testimony of the persons. So normally nowadays testimony of the persons are drastically falling down. We need to depend upon the other evidences, 2 evidences. One is the indirect subjective and indirect objective. But here in my lecture, in this today, my concern is the indirect subjective evidence. What is indirect subjective evidence? It is the evidence based on personal experience, facts relating to crime about victim, suspect, object of the crime, witness of the accused motive, plan, preparation to commit crime. This new law has been stressed on this point very much. For that, they have incorporated so many things, relevancy word and maps, charts, they brought it into effect, and all the digital document they brought into this section. Reason is you can enrich the, so one example I give it to you, why this is important. What role IO are the public prosecutor to make a effective role. How many people have seen the Rajamouli movie Bahubali? Everyone. Okay. Is there any other director who you knows? Any other director you knows? Some director name? Tell me some other director name. Huh? So he is a good director. I can't consider another. Okay, average director. Average director. Huh? Okay, someone name. Mahesh. Mahesh Bhatt. Okay. If one story has been taken, that story has been given to Rajamouli as well as Bhatt. Okay, both the story has been given to both the people and make them a movie. Once they made a movie, whose movie you will watch? You selected one story, the same story you have given to Bhatt and the same story given to Rajamouli. And whose movie you will watch? Please answer me. Huh? Rajamouli. Anything else? Unanimously, Rajamouli. Why you have selected Rajamouli? Both are the directors only. Story is the same. Why you have selected Rajamouli? Please, sir.
He directed the movie in such a manner that it is different from more attractive.
Huh?
He directed the movie in a very excellent manner.
Very good. What is the qualities he have? That I wanted to know. Reason is that quality I wanted to see in you.
Presentation.
What is those qualities? What direction qualities he have? He present, narrate the story, he select the characters very well, and he will extract the good quality from the characters, and he will present multimedias into this one, effective multimedias, and present the story in a more effective, convincing manner. That is only. Now I am asking you to play such role in the court. You should be a good Rajamouli's. Reason is you need to convince two people. Okay, I need to convince three people, but you need to convince two people. Who are those two people you need to convince? When you wanted to get the positive result for your case, to whom you need to convince? Who are those? That is only I know that court only. Who are those people?
Defense counsel and the court.
That is all I mean. You need to, if you believe it, what charge sheet has been placed, it is sufficient as per the law, is not the right answer, right prospective. You need believe to, that means not only my belief, I need to make believe two more people. Thus, that concept, if you keep in brain, then you have success rate will increase. What we will do at the charge sheet time? What I know, what I believe, that is sufficient. I am right. देखा जाएगा बाद में क्या होगा? That is not the. You need to keep in mind two more people I need to convince. Then only I can take a positive result in the judgment. So for that only, you always need to keep in mind, means this role, evidence based on personal experience, facts relating to crime about victim, suspect, object of the crime, witness of the accused motive, plans, preparation, commit of the crime. This is the IO and the PP has to work together and collect as much of information about the case and present those case in a just like a Rajamouli presentation way. Then you will get a convincing weightage to evidence. So you may ask that what is the benefit in that presenting the things? Same character kahani. Why one director has been liked much? Why you selected? That means you presented the things in a same story only. Evidence is the same only, but you are convincing more effectively. Then you will get a more weightage to that evidence. So that is here I am trying to imbibe here. So indirect subject to evidence. Indirect object is evidence based on scientific examination. That is not a major important. The expert's opinion will be there. So now I wanted to stress on indirect subject to evidence. Means in this Adhinayam also, they have taken care about this point very seriously. Further, they have incorporated so many places, but those are all kept in the relevance word only. Means you need to wherever the relevancy is word is, that means it is a discretory power of the judge. So you need to convince the judge. That means it is relevant, sir. Please kindly look into this. Okay, then you will take into consideration. Okay. So indirect evidence is the perceptual variation, memory variation, expression variation, class variation, subject. This is an individual person already how our information will be stored in our brain. दिमाग में कैसे स्टोर होते हैं information? आपके किसी का दिमाग में है कैसे जाते हैं इंफॉर्मेशन?
The top question, sir, we are not getting.
Not getting. It is going through 5 sensors only. Anything else it go? Only 5 sensors only. If the person when you are talking about witness, the 5 sensors are not working properly, his brain will register information? No. Okay, the sensors are working, but his memory is not good enough to store that. He will stay true statement? No. Okay, if the memory also good, but he don't have communication modes, then he can't able to communicate. Okay, all 3 is there. Still, society is a favorism society. So furtherly, he try to favor his own community, caste, creed, and all those things. So class variations will be there, and individually has some other problem. For that only, memory is such a thing, so it can't see the thing, but it can't store every things in our brain. So furtherly, everyone listen story, but everyone can't remember. That is only. These disadvantages are there. For that, they need to go to other evidences, indirect evidences, and these are all time tested, demonstrable, repeatable, universally accepted, and without bias. So man may lie, but material, object, and circumstances do not and cannot lie. That is the basic funda behind the information circumstantial evidences. Evidences is physical evidence. It relates to physical evidence. IT Act also related to physical evidences only. This is document evidence. Now it becomes. So it may be small or big, visible or invisible. Okay. So physical evidence is divided into 2 types. One is movable evidence and movable evidence. So if movable evidence means which I cannot shift to court or the expert place, then that is called immovable evidence. So immovable evidence which can be collected and placed into place. But now immovable evidence is there, then I cannot move. What is the use of that evidence? What I need to learn? I need to learn the transfer techniques. If it is any immovable thing is there, shoe print is there, blood pattern is there, so I cannot shift a wall, or fingerprint is there. Can I shift the on the table, along with the table? Not possible. Further, what we will do? We will know the transfer techniques. Then we will transfer those evidences and we will send to expert, then afterwards to court. If it is a movable evidence, can easily move and pack and learn and send we will continuously. But now I am talking about digital evidence. Which category it comes? It comes under that category or this category? Question is this. For you, question is this. Which category it comes? So, answer, please think over it. It comes under which category? Movable category के अंदर आते हैं, immovable category के अंदर आता है.
Physical.
Movable, immovable, but it comes under both the categories. It comes under both the category. So if it is a mobile, the evidence is there inside that. So now it is a movable. I can move along with that carrier. It is a file is the evidence, but mobile is the carrier. So I can shift the carrier. So it is a movable. Along with the carrier, evidence can be shifted to somewhere, and I can. If it is immovable, if it is a cloud, can I move the cloud to court? Or if it is a server, can I move the server to? So these are all I cannot shift to court or somewhere. There, what we need to know, I need to do transfer techniques. I need to learn. So what is the integrity? If it is immovable, then expert will give the documentation for that. If it is immovable, whoever doing the transfer technique, that person has to make a, in the IT Act, that provision has been given to under the 65B certificate. But in this new law, it has been given annexary B morning I have shown that document has to be generated along with in 65B. There is no question of hash value, but now it has been incorporated the hash value. These things has to keep in mind. Now I will try to go to crime scene. Reason is for the investigation also, you wanted to present crime scene is one of the most important thing to focus it. I don't go much about this. I will skip everything. I will try to present what I need to be done. This important chapter I need to keep it in mind. So normally at present I was when you're talking about scene of crime, what they brought to you. आप अभी तक आप लोग बहुत cases देखा होगा है. IO लोग, if IO, what he will brought when at the time of charge sheet regarding the scene of crime. Your experience. Scene of crime के बारे में कैसे क्या लेके आते हैं आपके पास? He brought it.
Circumstantial evidence.
Material लेके आते हैं. उसकी कहानी वो किधर हुआ, कैसे हुआ, ये सभी किधर से लेके कैसे लेके आते हैं? On paper, by photographs. So sometimes maybe some people are using, but earlier normally they in the narration only. They will come with the narrations only. But normally when we are shifting to digital mode, 4 things has to keep in mind. First one is the field notes. He has to write what he has seen. And second one is the photographs. When field note is there, what is the need of photography? When the field note is there, what is the need of photography?
More clear. To get the clear picture.
Words may change, photo don't change. Reason is I draw it today. When I ask after 1 year, your words will change. Same words you can't repeat, but photo will change. It will say same thing. That day, what 1 year back, what it told, today also it will told same thing only. So that is the basic difference between the photography and the words. Then what is the photography is there? What is the videography? Need of videography. It is a one frame only. Photography is the one frame. I wanted to see the total scenario, what it have been in the sequence. Then the videography is the only solution, what it has been, complete system mein kya hua hai. So there is no continuity. In the photograph, there is no continuity. For the continuity purpose, videography, okay, videography is done. Then what is more? Crime scene sketches. What is the need of crime scene sketches? What is the need of crime scene sketches? What is the utility we are maintaining? Any guess?
No. Immediately you can imagine the
answer. Anyone? No.
That speaks about the topology of the situation. Is there any answers or how?
Yes, that is the measurements. Reason is in the field notes he may write it, but he can't know where it is there. The house length is this much only. So in the photographs, no scale can't be kept. It means in this room I taken a photograph where I should keep. So that is the one issue. Scaling cannot be done photography. It is only small objects I can take a photography. If it is a outside videos, photographs, I can't keep the scale. So I cannot know that means which is the total length of this room. So furtherly videos can't explain. For that sketch is the only solution. So for that only, why I am telling to you, sir, हम तो हमारा काम तो है ही नहीं भाई, बकवास में आप हमको क्यों समझा रहे? ये तो क्वेश्चन आपको आ रहा होगा, चाय पिलाया बिठा के फालतू बात कर रहे हैं. My concern is that you are the checking officer before placing in front of the court. You insist these 4 items from the IO. Tomorrow at any time, in the proceeding time, defense lawyer will ask any question. If you don't have data, at that time scene of crime won't be available. So further, the data won't be available. So further, you should make it all the information available. So furtherly, I insist, you people tomorrow any charge sheet come, any scene of crime issue comes, so may come with all these 4 modes. Then you can make and convince, you can be good Rajamouli. Okay, you can be a Rajamouli. You can be a good director in the court of law. So that is my intention to make the available things at the time of charge sheet. I am not going to these are all those things. Already I discussed. I don't need to explain to this what is the photography and all those things. This is the videography sketches, and this is. And I will go few things. Now we need to change according to the scenario. I have covered 4 things, but few places where the IO can't reach. At that time, how I can be done photography? Now we have technology supporting. So the technology is the drone. So an unarmed aerial vehicle. So we need to upgrade our technology in the investigation process. So our investigating agency also come with this facility. And I am not going to discuss this unarmed aerial vehicle, remote piloted vehicle and drone. These are the vehicles that need to be updated. And one more thing is that one more issue we need to taken care about it. Now we are surrounded by surveillance systems. Everywhere we are covered the surveillances. Means, okay, scene of crime photography has been done or videography done or not done, but by grace of the surveillance system, it is already recorded in the places wherever the crime has been happened. So now we are the investigating officer or the prosecution side. We need to ask the investigator, stress on investigating whatever the CCTV footages are available around that area. So you need ask him to encourage to collect the reasons. At present, digital evidence is a documentary evidence. It is a prime evidence. So you need to utilize that evidences more effectively and convince the judges. That is my concern, is that to put in. So we are all covered by surveillance system. Wherever you may go, we are all covered. So it may be a railway station, it may be a parking area, it may be highways. It will be used for understanding the behavior of the person also. It is mob culture. If you want to understand how they are behaving in the railway station, it may be in the highways. So you can able to see. And also one more thing is in this one is, it is not eyewitness man in the night he can't see, but night visions can see. So one more benefit is that it works in the night also. If a light is not there, still it works. So it is a one more facility is there. And afterwards, one more thing, now the technology has been there in such a high, the resolutions are very much high. So now we can able to vehicle numbers also we can identify. If someone in the Bhubaneswar, the system surveillance systems is available. So wherever my vehicle is going on, they can catch hold. So where this vehicle is, in which routes it is running. If they are keeping on the surveillances on the roads, it will register and measure, identify this is this time, this vehicle can be passed in this road. So they can able to say. So these are the benefits in the all those things. So now I told them why the sketches are the means it is a normally rectangular coordination, triangular coordination, and cross projection. These are the different methods it will be used. So this is the sketch mode, will be crime scene sketches. So these are all helps you to, why these are all required is that these are all extra tools to show, to convince the judge to become your direction more effective. So it fills the gaps very effectively. Okay, these are all maybe not major evidences, but it will gives the story is the same only. I told you example is the story is the same only, evidence is the same, but you are adding the value to that evidence by these are all. If you collect, ask him to investigating officer to collect all the information, then you can present the case more effectively. So I am not collecting evidences, it is not related to you. I will skip it. This is our concern topic. I will go to. Pardon? No, it is not. No, yeah. अरे ना बोलते हैं ना हम घर की मुर्गी के कहानी हम ही जानते बोलने हैं, तो मीन्स हमारा मुर्गी के बारे में हम सोचते हैं, दूसरा मुर्गी के बारे में वो बोलते हैं, हम भी ऐसे है, ठीक है? So it is only we don't appreciate ourselves only. Don't. It is not like that only. But they have their own problems. They will say that means sir हमको investigation किधर करने दे रहे हैं? Where the investigation allow us? We are always busy with the law and order only. Okay, so they have their own difficulties, but still We need to work. We need to improve. The working in the smooth, sailing in the smooth boat is don't give the fun. Where the trouble boat is there you will sail it. Then that gives the credit. I have crossed in difficult situations also. That is the spirit we need to have. Normal sailing, anyone can do. What is the need of me to be there? If I am there, there should be a tough situation. I should cross that tough situation and prove my efficiency. So that spirit I need. Okay. So बोलने के लिए बहुत बोलते हैं सब बोलना, but we proved it. Okay. So now I try to talk about. So why the IT Act has been brought it? This is the basic revolution of the information technology brought into picture. So due to that only, now we are shifting to implement those technology into our judiciary system also. Any problem? Okay. So in this one, Locard's principle, you know, that means basic forensic science works on this principle only, investigation starts only, physical evidences works on this basis only. Whenever any interaction takes place, that interaction one leaves to other. Means anyone in anything entering a crime scene takes something of the crime scene with them. They also leave behind something themselves with them, depart. Now, whenever it is digital evidence also, whenever it is incorporated somewhere and it leaves its traces also. That is one more thing. So what is the difference between the cyber crime and the computer crime? I use the word cyber crime. It is the same as computer crime?
No.
What is the difference between?
It can be done anywhere in the world.
Cyber. Reason is you are all connected to cyber world, or you are connected to yourself only?
Cyber world.
You are all connected to cyber world. Reason is we are all doing in the working under the cyber world. Reason is everyone mobile is connected with the internet. So you are all part of the cyber society. Okay, part of we are the cyber society creatures. Okay, now we are all, so that means we are also have a chance to do crime, or someone may chance to do crime on against. So we are more vulnerable. We are more vulnerable due to this cyber world. So cyber crime is defined as a crime in which electronic communication device is the object of the crime used to target user incident or witness or the commit an offense. The cyber criminals may be information technology, access personal information, business route. That is all you know, that I don't need to mention, that is only. So this is only, earlier crime happens, it happens in different way. At present the crime happens everything through internet. पहले burglary करना होगा तो हमारा window तोड़ के someone break the window and come inside. But now they will come into your mobile and take away your money. Okay. Now earlier deception calls, someone make a call and insult you, be coming to your home and he will insult you. Okay. So he will shout on coming to your in front of your house, he will shout on in your house on the street. You did that way, you did that way. But no one did nowadays. They will all do a paste in the Facebook. Cyber world. Defamation. So usne ye kiya, mere ko ye kiya. So that is the fishy. And extracting also the same thing only. Extraction also earlier they come and extract the money. But now it is all through internet or mobile or something else. Or frauds also happening through, earlier it is doing with the direct contact frauding. But now everyone is internet frauding only happening. So frauds are also changed. Identity theft. So identity theft also not happening in the earlier direct person, but now it is happening through internet only. So child exploitation and all those things are, everything is nowadays, it is most of the crime happening through internet world. So we are more vulnerable. So evidence is evidence. Means whatever the information it is, evidence means information leads to information. That is regardless of whether the evidence is physical trace, it is must be same rule, integrity must be maintained. Earlier for the integrity, what we do, we compare the seals. Normally in the court, what we will do, if the physical evidence received, इन्वेस्टिगेटिंग सीजर ने सीज किया है, सीज की टाइम आईओ ने सील किया है, वो सेम सील कोर्ट में अवेलेबल एक्सपर्ट ने देखा है, वो कोर्ट अभी भी वो कोर्ट में आया है, सेम सील का मैच हो रहे हैं. So these are all only seals we are matching and finding that integrity is perfect. But in the digital evidence, it is not the case. So it is the integrity is measuring in some other way. It is called hash value integrity. We need to. So types of evidence is the primary and secondary evidence. So already I told, but now it is in the electronic system, how the information has been stored. कंप्यूटर में कैसे स्टोर होते हैं? आपकी गाना की स्टोर होते हैं क्या? मूवी की तरह की स्टोर होते हैं क्या? हाउ इट स्टोर्स? मेमोरी. वही मेमोरी कैसे स्टोर होता है? गाना की तरह से स्टोर होता है. So it stores in the zeros and ones, but it don't store zeros, ones and one also. In the computer, in the memory chip, there is a material called semiconductor material. It is the when the power supply is there, some molecules get activated, some molecules don't get activated. Which is activated, that is called 1. Which is not activated, that is called 0. क्लास में खड़ा हुआ कुछ लोग, वो तो 1 हो गया है, खड़ा बैठा है वो सभी 0. So the molecule consists crores, lakhs of molecules will be there in the small element. In that one, it can store number of zeros and ones. It can store lakhs of crores of zeros and ones. So the combination of those zeros and call it as a binary numbers. Those are all called. We can't say that means it is a active, non-active. For that we categorize as a mathematical 0 and 1, and we in that mathematical theory we calculate into a one pattern. So that pattern is called mission language. That is called mission language. Memory stores in active, non-active. That non-active, active converted into a mathematical formula. Further, we convert it to zeros and ones. That zeros and ones combination, mission language converts into a. That mission language convert the zeros and ones into a some information. But that some information cannot be a song or anything else. What need required? What it required? What it required? When computer run करना हो तो क्या चाहिए आपको? When you wanted to run the computer, what are the things are important? What are the basic parts in the computer? CPU. So if it is that all those things run, what it required?
Monitor.
वो तो है हार्डवेयर, सभी हार्डवेयर और बॉडी तो है, इसके अंदर प्राण नहीं होगा तो क्या कर? सॉफ्टवेयर के पहले क्या होना चाहिए? ऑपरेटिंग प्रोग्राम. व्हाट इज रिक्वायर्ड? बूटिंग करना होगा तो क्या, कैसे वो सिस्टम ऑन करना होगा तो पहले पावर सप्लाई होना चाहिए. पावर सप्लाई होने के बाद क्या होना चाहिए? व्हाट इट रिक्वायर्ड? ऑपरेटिंग सिस्टम होना चाहिए. दैट ऑपरेटिंग सिस्टम कन्वर्ट द मिशन लैंग्वेज इंफॉर्मेशन इनटू ए फाइल. Then that file converted into a, which one? It is operating software converts into a song, word or anything else. So these are the mechanism. It converts active, non-active into a song is that these steps has to be covered. These are all we are not seeing. We only see song or word or anything. It is active or non-active, Bhagavan knows. It is zeros and ones, Bhagavan knows. We don't know anything, but we know only it is a song or word. That is that. So for that only, it is such a complex and such a volatile. Why I say these things is that these are all such a complex and such a volatile. So for that only, we need to be, if things are more complex, more volatile, we should be more cautious. So we need to be more cautious regarding those things. So how it is has been changed, I am not going to. So this is the electronic evidence. It is invisible. Problem is volatile while SMS, it is invisible. हमको पता नहीं कैसे है, what is there. It is easily altered and destroyed. इसको आसानी से स्पॉइल कर सकते हैं. Requires precautions to prevent alteration. इसको बचा के रहना होगा, तभी हम बहुत सावधान रहना. कितना एग्जाम्पल बोल लेता हूं. अब कितना लोग शादी किए? सब लोग शादी किया, 2-3 लोग छोड़ के लग रहे हैं. ठीक है. So शादी के टाइम में तो सीडी बनाया होगा, शादी का सीडी. अच्छा, वेरी गुड. अच्छा, कैमरामैन को बुला के यूए तो लगा के, व्हीकल लगा के, प्री वेडिंग सेशन भी किया है, सब कुछ किया है. इसके बाद 5 साल के बाद उस वीडियो को कभी उठा के देखी? कोई नहीं देखता. एक बार शादी कर दिया, वही समस्या भाई, दोबारा नहीं देखना भाई उसको. एक बार गलती की, यही तो सोचते हैं. ठीक है, कभी कभी उसकी शादी बहुत अच्छी चल रही होगा, 5 साल के बाद चलो दोनों मिलके देखेंगे बोल के वो सीडी निकाल के चलाएगा तो वो चलती नहीं है, ट्रक होते रहते हैं. सही नहीं सर? हमको देखा ही नहीं होता, हम कैसे चेक करेंगे? तो हमको पता ही नहीं. हम तो 1 साल में नमस्कार कर दिया वो शादी को. 5 साल के, when you see that after 5 years it won't run, reason is it is easily spoils. So for that only it requires precautions to safeguard that, and requires special tools and equipments. I had already told, means this is the complex, the zeros and ones easily don't convert into your song or picture. It requires special tools to extract that information, requires specialized training. People also need to have some specialized training to extract what they have seen, same information without damaging, without altering, without modifying. It need to be converted into things. So for that only, this some accuracy is a expertization required. For that only, these are all need to be taken care about when you are dealing with the digital evidence. So it is a, that means what are the things are there, what is the electronic evidence, different modes are there. I no need to mention. There are now the clouds are there, everything is the servers are there, pager, these are the different. So normally we come across in the courts basically 3 types only. It may be audio, it may be a video, it may be a text. So whenever the big commitment of cyberspace is that process of almost recorded in a digital fashion. Now what we need to know is that means acquisition, authentication and admissibility. These 3 factors we need to take care about it. कैसे हम acquisition करेंगे, कैसे उसके data को extract करेंगे. First, that thing is to be known, and second is authentication. How to maintain the authentication? That means that is the original data only. That is brought from that one only. That is called authentication. And admissibility. It is legally admissible or not. It is a validity is there in the court of law or not. These 3 things has to be taken care by us as a public prosecutor. Whenever any digital, how they acquired and how it is an authentic information or not, then it is a legally admissible or not. These 3 factors you have to keep in mind whenever it is a electronic evidence comes in your place. That is, I don't need to be. And challenge of electronic is by its very nature is invisible. Already told, developing tools other than tools, knowledge and process must be documented, reliable and repeatable. And in this one, whoever may be collected, he has to mention, already I told that this morning the certificate generation 65 and BNS. BSA under I have mentioned that 65. If you go through, then in that one it has been mentioned what are the things. 63, I think, sorry, 65, 63. So 63 it has mentioned that means what are the steps has to be followed, what are the precautions he has to. In this one it is given that means the person what type of tools he is using, from which thing it has been extracted, what type of tools he is using, what type of commands he is using, all those things has to documented. Okay, that is only it will reflect, that means he done a same data what he has seen. So that is the thing has to be understood. Acquisition evidence is both in legal and technical problem. So you have to take care about it, means legally it is will be proved, that means the same information only he brought it. So that is the IT Act, the same electronic card. It has now definition has been much more clear. So I no need to repeat. Chain of custody, already I told that means for that there is there to be some SOSP has to be generated from the State-wide. Means state has to generate what type of SOPs, what type of material के लिए हम क्या format follow करना. Then only they can IOs can do in that format. So that is a more important standard. So this is a different techniques we are using. It may be computer forensic, network forensic, mobile forensic, IoT forensic, cloud forensic, voice forensic, photo forensic.
Just a question, sir.
Blow
What
more.
is the basic difference between electronic record and digital record? What is the basic difference, sir?
Electronic record and digital record, record wise both are the same only. There is no much difference. Record, if you call it as a record, electronic record and digital record both are the same only. There is no, only simple is that electronic record can be IC oriented, but digital recording is a processing oriented. If we go into much more deeper, technical wise there is no, but now the IC systems are removed, all processing system only. Earlier we are working electronic mode only here. Now we are shifting completely to the processing mode. So many ICs become one processor. So now we are not using ICs, electrodes and all those things. Simply we are using processors. So whatever the processing is done, it is based digital evidence only. Okay. Are the difference between आप इलेक्ट्रॉनिक्स पढ़ेगा तो समझ आता था. पहले क्या होता था, आप रेडियो पहले पुराना कोई बच्चापन में रेडियो देखा है, इतना बड़ा होता है, ऐसे भी नहीं होते, उसमें है, उसमें ट्यूब्स होते था. मेरा बचपन में मैंने देखा, मेरे घर में एक रेडियो होता, उसमें इलेक्ट्रोड ट्यूब्स होते हैं, वो तो गर्म होते हैं, रेडियो चलेगा तो गर्म हो जाता पूरा. So ऐसे होता था. मीन्स दूसरा that is electronic based. Now we are using process based. Processor you are using, कंप्यूटर में कभी भी processors होते हैं. अभी we are working on the processing mode. So combination of all those things will be there in within one processor. So those processor is called digital based. So both processor is also an electronic item only. So but we are using it is a much more technical oriented. So we are using digital. But when we are talking about morning item signature, that is different. Okay, data is the same. Electronic and digital data is the same only. Now I come to topic of the forensic imaging and forensic copy. So आप लोग सुना होगा, कभी सुना IT लोग कितना लोग डील किया, IT cases कोई डील किया इधर? Anyone dealt with this? Dealt. Okay. So anything, sometimes IO experts will give, this is the cloned copy or imaged copy. Sometimes they will say simple copy. What is the difference between these two? Who are they? उनको बोला. राइट स्क्रिप्ट ले आना. स्क्रिप्ट फैसिलिटी है, पेंट प्रोग्राम है. Open the paint. Open this paint. Scared. Okay. Okay, so thank you. If any imaging is that if one file created in the computer, what it will do? How many files it makes? If you create one file, how many files will be created? You know anything? It creates 3 files. It creates 3 files. One is that, sorry, my writing, it is not writing very well. So 1, three, okay, you leave it. Okay, one file is your online file, which is your name, your name. When you created one file, automatically in the background, what it will do, one backup file form. Automatically, when you make one file, automatically one backup file that won't be visible to you. It will be backup file will be formed. Among these two, Third one is the log files. That is called log files. Means when you created, who created, in which computer it has been created. So like that, 3 files will be formed when you make a one file in the computer. But what you will do, you use only one file, but remaining 2 files, you don't know those are all existing as a normal person. Technical experts knows that, but normal person, people never bother about if their file is existed or what is its log files are there. You are not bothered about it. So now I copy your file to in pen drive. What it will go? If you copy your file, what will happen? All the 3 files will go?
No.
Only one file will go. All files won't go. It is only one file will go. That is the only file what you are working. Backup file don't go and log files don't go. It is only file what you are working that only goes, and it will be pen drive, in the pen drive. Okay. So like that only, that is called copy. Simply copy. When I am talking about imaging, when I am talking about the image, forensic image, what it will happen when I make a image, all 3 files will go. So as it is as equivalent to original, it is just like a clone. We are used the word name as clone also. It is as it is, I am creating the different document for that only. So it is equivalent to original. Clone is nothing but a equivalent to original. That we call it as imaging word. So that is the difference. When I wanted to study anything, so I can work on the image also. It is equivalent to original itself only. You got the difference?
What is image? What is copy?
I told now only one file is.
Okay, what is the difference between copy and image? I will copy this file to another
one. That is only file is going. Remaining two.
Image?
Image is all 3 goes. Then it is an image. Got the word? When you make an image, on what grounds you created background file, log file, all goes as it is, as I told that with zeros and ones. It will copy as zeros, ones only. It won't copy only file. It will copy as zeros and ones. Got the point? And how I can interpret that zeros and one? That is my program, it will decide. But in this one only, it will copy zeros and ones, but in the file, in the Word file or the whatever the format you have given, that format only it is copied. So you got the technical difference? Anything clear or not? Is still in confusion? Huh? Okay. How many people knows about the deleted file concept? Okay, when we are delete the file in the computer. Huh? When you file deleted in your system, what will happen? Very good. My right answer. I appreciate. When you remove it from recycle bin, what will happen? Permanently? It means it is there in the system or not? It is not the right answer. It is there in the system. I will explain. Okay, if I created one file, this is the data. What happens system in the computer? Normally, whatever the data you have stored, it won't store in one place. Okay, it takes 2-3 places, locations. इसका एक रूम अच्छा नहीं लगता, दिन को 2-3 रूम चाहिए. So उसी के लिए it make it sometimes it may 2, it may 3, it may be 4, like उसका probability के अनुसार it will select number of places. Okay, it gone and settle in different places. When it forms, it will divide into two more things will be added to that data. Two more things to added to that data. What is, this is the data. Our data is this one, which one I have drawn. But along with the data, two more tags will be attached to that data. That what is that is the first one is the address. First tag is the address. So each one it will attach with some address. So each data को एक address दे देते हैं. साथ साथ metadata m. What is called metadata? There is a one tag will be added that is called metadata. Metadata means when, whom, where it has been created. That will stored in the m places. Okay? M places में क्या store होते हैं? Who stored, on which computer stored, at what time it is stored, what time it has been edited. Those are all information will be stored in the M. What is there in the A? Address. So where this data has been allocated in the computer, that address will be there. When I search my file, Ramesh file, then it will go, okay, his address is in 2-3 places. So all addresses it will collect A1, A2, A3, and it will collect and gives my picture. If it is my picture is there in that one. When I delete it, what it will do? A become R. A become, nothing is changed. Where it is there, there only it will there. Metadata will be there. Data also will be there. Only address will change. मेरा address कलकत्ता से अभी क्या है? कटक हो गए हैं. So furtherly, my address only changed. I have not changed. Where am there only? So data will be there only, but address only. The system when searches, it will go and recycle address and it will collect data as a recycle name. Okay, when you delete the recycle also, what will happen? The data become addressless. माँ बाप नहीं रह जाते उसको हो. कौन है? उसका address ही नहीं रह जाते हैं. Data will be there. Only its address will leave. So data will be present as where it is there. Only the address column will be blank.
Then whether that can be recovered?
That is what I am telling. So when good question. Like that, the brain should be active, very sharp. Then only you will get answers. Okay. So furtherly, when it is the address is not there, how it can be searched? Furtherly, our normal systems can't search. But the forensic tools are there. They have developed different mechanisms, different softwares. What they will do by analyzing the metadata. अभी 1 सेकंड में मैं 2-4 फाइल तो बना नहीं सकता हूं. 1 सेकंड में एक ही फाइल बना सकता हूं. So it will search according to the time metadata and collect those files all 1 second में क्या इसने क्या काम किया है वो सबको इकट्ठा करके 1 फाइल बना देती. समझ गए पॉइंट? Agreed? Logic is agreed. So like that it will create a 1 file and it will can be done in the forensic tools only, not with the normal computers. So now if any deleted data is there, we can extract. सर कभी कभी कोई आई वो पूछ सकता है डिलीट डेटा पूछने के बाद भी वो एक्सट्रैक्ट नहीं कर पाए लैबोरेटरी में. Why it is that? What it will happen? Okay, if I say that one example, 2 photos are there. My photo and my wife photo will be there. What will happen? I have removed my photo, deleted my photo. That means only address is gone, photo is there. First, in the first portion, my head is there, and the middle portion, my body is there. In the bottom portion, my leg will be there. Okay. Similarly, in this photo, head will be my wife head will be there, body and legs will be there. When I deleted, this address has been removed, and this data. When I put my photos, my wife photo into the system, what will it will select randomly wherever the address is also not. It may select new, or it may select wherever address is not there, that can select also. What the system has been done, it selected my head portion with the legs of my wife. Okay, it selected and it was not deleted. It is there. Only this has been refilled with legs, and these two means five data won't be there. 5 data only there. So if it is 5 data is there, if I extract my photo from the deleted data, what will come? What do you expect? What will come? My photo will be headless. Reason is my photo is consists at my head place. What it is there? It is my wife's head is there. So further it can't extract. Reason the question is not asked. That means it is Ramesh wife photo. It is not asked. It is only Ramesh photo should be extracted. Ramesh photo, how much it is there? It is only body and legs are there. There is no head. Further, if it is not able to extract that one, so that is the concept of the how it deleted data can be extracted. That is that is called tracing. Tracing of the data means traces of the data can be. Sometimes if it is a video, that is called grafting. We call it as a grafting. Means some images will be there, some images we don't get it. So video means nothing but a frames, number of frames. So some frames we will get it, some frames we don't get it. So this way it works. Sorry, can I? So when we use the wiping, what means formatting, wiping. When it wipes, that means it completely delete every data and rewrite some other data, useless data, all zeros, all ones, it will record it. And due to that, it will overwrite all the information wherever the blanks are there, it will wipe out. Furtherly, sometimes you may get it, sometimes we may not get it. When wipe also it is possible, but depend upon how much wiping has been done. Okay. Now we will come to your issue, hash value. So what is meant by hash value is that it is the mathematical algorithm and with the nomenclature in the numbers and alphabets. It is a combination of alphabets and numbers having tag. It is calculated, mathematical calculation done on available data. So that software has generates, but it is one side only. It is a one side only. The data can generate the hash value, but hash value cannot generate the data. You keep in mind, it is not reversible. One side, one way only. So data can calculate, we can calculate the data, hash value with the data, but we cannot calculate, enhance the data with the hash value. Okay. So that is the basic difference between the hash value. So there are different methods are there, hash value generation. Normally MD5, SH1, SH2, SH2, there are different methods. Normally we recommend for all the things only two, only MD5 and SH1. Normally in the document also certificate is given, there were only two hash values they have recommended to generate. So now how to generate that hash value? So if you go through your mobiles, Play Store, how many people can see? You can check it, the hash generator, hash checker, any tool, download. सब लोग प्ले स्टोर में जाना है, हैश जनरेटर. आप लोग प्रैक्टिकल तो करने के लिए मांगा तो है. हैश जनरेटर, हैश चेकर, hash checker, any one of that, hash checker or any whatever way you wanted, hash checker or hash generator.
इंस्टॉल करूं?
हाँ, इंस्टॉल करना. प्ले स्टोर है, कोई डरने की जरूरत नहीं. डाउनलोड इट. hash checker, hash generator.
hashtag generator.
हाँ ठीक है, डाउनलोड कर लो प्ले स्टोर में। प्ले स्टोर सिंपल है, प्ले स्टोर में क्लिक करो। प्ले स्टोर किधर है? प्ले स्टोर में जाओ। प्ले स्टोर किधर है? गो थ्रू द प्ले स्टोर एवरीवन। प्ले स्टोर में सर्च में डालो।
MD5 आया।
हाँ
इसे आया।
हाँ कर दिया ना। फिर देन यू आपने सेलेक्ट कर लेना, उसमें है
MD5।
MD5 सेलेक्ट कर लेना है। गो टू फ्रॉम में जाओ। हाँ क्लिक कर लो, इंस्टॉल कर लो।
फाइल।
हाय देन यू गो टू फाइल, select one file, select one file and go to action and generate. You got the hash value?
Okay.
Okay. Install कर लेना। So whoever learned, teach to someone else who are nearby. हाँ सामने वाला साथ वाले
हैश वैल्यू डिफर कैसे होगा? टेम्पर हुआ है कैसे जानेंगे? टेम्पर हुआ है नहीं कैसे जानेंगे?
Okay, very good. Now, when the IO did one file, created one file, he generated one hash value. He has to mention his generation. Okay, now it is comes to you. Same file you generate hash value. If it is the same hash value comes, if it is in what format he generated, same format you have to generate. MD5, SH1, which format. If it is same hash value comes, it is not damaged or it is not tampered. Simple. Locked seal has been verified. Verified or not? That is simple logic. Wherever any file is there, but one condition, you need to compare the hash value for the files only, not for the pen drives or hard disk. Complete. There is a two methods. One, I can measure the complete pen drive, also I can measure the hash value. मैं आपको इंस्टॉल करने के लिए ये पूछ रहे हैं, इंस्टॉल हो गया फिर क्यों आया? ठीक है बोल लेता है, एक मिनट सर क्लास कंक्लूड करने तो बाद में भी समझा देता हूँ। Why it is that? I told that means whenever pen drive or anything, in that one there will be a formatting program will be installed in that pen drives. If आप मार्केट में कोई भी खरीदेगा तो उसका इंस्टॉल करने के लिए एक प्रोग्राम उसमें अंदर रहा होते हैं। आप सिस्टम से एक पेन ड्राइव से इस पेन ड्राइव को कॉपी किया, then what will happen? That one have different program. If this one have different program, if you hash value generated, if your data you have copied, but the program you have not copied. This program is different. Automatically the data will be different. Automatically hash value will be different. For that only, never measure compare the hash values of the hardwares. Only you measure the hash values compare the hash values for the individual files. Then only it will be.
Sir, actually, voice recording.
Any file, whatever file it may be, if it is in the file format, it will give the hash value, irrespective of anything. If you keep it white blank sheet also, it also gives the hash value. Okay, any digital mode. So should I conclude? Okay, sir. Thank you. We will close it out.
Thank you, sir.
It is endless.
Right. That's right. मैंने समझते बुझिले कि the last statement that sir gave regarding since you are prosecutors dealing with matters of these kinds every day, sometimes what happens, the investigators or the agencies that whose help they take, they normally bring the hash value of the entire digital device. What the resource person says, every digital device which is capable of storing some data comes with an internal software. That software is known as the programming, on the basis of which the digital storage device works. Maybe FAT32, FAT16, there are formats, number of files are there, which are already there in that storage device. When you copy a particular file into a blank storage device, your file is stored in the name, suppose it's a picture, .jpg, jpeg or whatever may be the format. So you are only concerned with the data kept in that file, not in the entire pen drive or flash drive or storage device. So once you take steps to bring the hash value of the entire device, what happens, as sir was saying, suppose I am using a particular flash drive which has a program of a different nature. You have copied data from my flash drive to your flash drive which has a program of a different nature. Both are blank. When you click the properties, it says no data inside, but still there is data inside. That is called as the program data. The program data of that flash drive or the storage device is there. We are not concerned with that. Your storage device data will not match with my storage device data. So don't go through that. If I have copied a file, find out the hash value of that file. As sir was mentioning, can it be a picture? Can it be a video? Yes, it can be data, can be stored in the shape of pictures or no video, moving images, or for that matter voice recordings, anything, because computer only knows two binary codes, 0 and 1. Any data we store in the computer is stored in a digital format. There are codecs for that. They decode the data, and when we have the output device, maybe a printer, maybe a monitor kind of a thing, we see the data in the desired method using a program which we have used for that. Suppose when you want to see a video, we use the video player or the VLC player, whatever may be. When we want to see a photograph, we see an image viewer. When we want to type out something, we use a word processor. So kind of that kind of a thing. So it's a request to all of you, all the officers who are also watching through online mode, that whenever such a matter comes to your court, please ensure that the hash value relates to the particular file where your required data is stored, not any other data, any other file. Okay, thank you very much, sir, for analyzing things in detail. Since we have come to the close of this program, I will not take much of your valuable time. Rather, I will request our Vice Principal, sir, to kindly come forward and give the closing remarks, after which I will be formally closing the session. Sir, please.
Good afternoon, officers. Good afternoon, sir. So we are concluding here 2 day session. I would like to take your feedback physically and online also. So what is the feedback of 2 days course? How you were on yesterday and how are you now? Must have gathered, if not much, at least 1% as you were here yesterday morning. And today at 5 p.m., you must have gathered at least 1% additional information about this new criminal law, or whatever you have been taught by your 3 eminent faculties. So any feedback from your side, so that I'll be happy and my team will be happy. Anyone, please, sir. Feedback means, I mean to say, any additional alteration in this training schedule, which is prepared by CDTI Kolkata. In this training schedule, anything you wanted to add, addition, alteration, like this. जो पढ़ाया तो आपको पढ़ाया, लेकिन जो शेड्यूल बनाया हमने, ट्रेनिंग मॉड्यूल जो बनाया, मॉड्यूल के अंदर कुछ कमी है, आप बता सकते हैं। मॉड्यूल में और कुछ जोड़ना चाहते हैं आप, वो बताइए।
Hello.
What's that, liquid?
Sir, the training
Training session is very attractive, but so far as subject is incorporated in the training session, that is also very valuable. But the fact remains, in the practical field, how it is applicable so far as electronic evidence is concerned, that part is not visualized or we are very much eager to know about the practical use, how a mail or other parts of images, and that what the investigative officers are collecting in the course of investigation, how in course of trial.
You wanted a practical,
No, how in force of trial that can be used.
Yes.
That is electronic evidence that is in record. That is in the proof. But how the mayor collected by the IO is to be
produced.
produced before the court.
Yes.
And how it can be brought into evidence. That should be impacted in the training program and that should be added in future classes.
I'll forward you, sir. I'll forward you the training module of the current financial year. So you can select your concerned PPs to attend at Day Kolkata virtually or physically, both ways. Sir, please.
Hello, sir. This training program, as far as this capacity building is concerned, I want to say, sir, we are actually working in that is in the code. That is the area of our functioning is that is in the code. So this training program, no doubt, is very much informative. And we practically learn much about this present, that is new introduction of criminal laws. But I do feel, sir, practically we are lacking while we are working in the court of law. That is, for example, a collection of presentation of forensic investigation or science. So that is all regarding that. That should be taught to the person, because what we are doing that is in the court of law is just like some postmortem works. We add something which is practicable when the law permits us. Some development we are making in the court of law.
Yes.
So here I practically want that as a prosecutor, I should know, first of all, clarity in the subject. That is a personal thing, but thing is that as a common, I would like to suggest that there must be comparative analysis of the provisions, so that it will be for a practical purpose. I'm saying that, sir. And second thing regarding is module should be prepared for the preservation analysis of the scientific tool. I mean clues. That is forensic sciences. So that will be expertise trial will be there, and we will be able to get the desired result of implicating the new laws. That's all.
See, this subject is vast. See, we have taken only 2 days in 2 days, how much time we could get for deliver the lectures and to interact with you all. 10 hours or maximum 12 hours. And in 12 hours, we have covered all 3 new criminal laws, comparing with the IPC, CRPC and PS Evidence Act. The time is quite less.
I'm just, sir, I should not be mistaken. Just whatever I am submitting, that is relating to capacity building. So when the question of capacity building is that I must be equipped with certain knowledge.
Yes.
So that I could comfortably work in the court of law.
Yes.
Comfortably work in the court of law. So if there will be analytical presentations, definitely it will be more helpful. I do feel so.
You invite us next time. We'll have your doubt clear in total, 100%.
That also required a very effort from our side also.
Because, otherwise, I said to your director, we'll be sending you this year module. You are most welcome. We are throughout the year. We are teaching.
Sir, I also request to my director also. Sir, before in giving this training program, we should be informed much ahead regarding the details, regarding the subject that you will taught, so that we can prepare best well ahead. That's also.
We'll forward our training detail. A total year training is on criminal law only, new criminal law. Total year. And in addition to normal courses, we are adding whatever instruction we get day to day from the BPRD or MHA. We also insert those courses with the scheduled program of the year. So we'll take care of it.
Thank you, sir. Thank you, sir.
Any officer, please?
Esteemed Badrinath,
आपका नाम बता दीजिए। प्रदीप कुमार दास। अरे तो अपना नाम ही तो এটা। वो प्रदीप कुमार दास बोलছিল। না ये प्रदीप कुमार दास। हाँ बोलून।
esteemed Badrinath sir, esteemed in charge director of Odisha Judicial Academy, revered Vice Principal sir, City Day Calcutta, Ramesh, Paul Ramesh sir, other respected officers, those who were on the front of the dais, my senior prosecutors across the state, and also my brothers and sister prosecutors. Really, I am very grateful and thankful to our Director Judicial Academy and also Vice Principal Sir, City Day Calcutta, that just before the yesterday, just before today, that we are very panic because just while the new laws, 3 enacted laws, we are going to commence. We are very panic that how to deal with the cases just after 1st July. But after getting to a 2 days training program, sir, really we got a lot of information, sir. Thank you for that, for this purpose, and also our director, sir, Judicial Academy, that we got a lot of information. Because if just we are panic that how to handle the cases, because just we have not gone through that entire books. So, sir, we got a lot of information. Thank you, sir. Okay, sir. Okay, thank you so much, sir. On behalf of our prosecution, also we are giving a lot of thanks and gratitude to you, sir. Thank you, sir.
Okay, thank you. Participant, all the best.
Thank you, sir, for the last minute discussion. Let me, before formally closing the training program, let me come to 2-3 points. The first point, as Mr. Das was raising, we acknowledge the fact that the 3 new laws will invite a lot of debate, not only amongst all of you, amongst people like us, people from the academia like Vice Principal, sir, people from across the society. They will be discussing various aspects of this law. And to cope with that, this training program or training programs of this nature, these are just the beginning. We are just beginning. And when we started designing these programs, we initially thought that no, we will not be conducting training program on the 3 acts together. Let us start with act by act. Suppose we are conducting a training on BNS, means it will only be on BNS. But when we further analyze the things, we came to know that no act, no new act can be studied in isolation. You need to have a comparison between the older act, the newer act, and the further newer act, and the acts which have come together at the same time, the BNS, the BNSS, and the BSA. And so these programs, and I'm really hopeful that in real near future, we'll be conducting much more programs. And what will happen when from July 1st, these 3 acts will come into force, we will also see a dynamics in the entire country where the Honorable Superior Court, the Honorable High Courts, and the Honorable Supreme Court, they will further interpret the law. A number of flaws will be found out, clarifications will come up, states and high courts will come up with their own amendments and rules. So whole set of new ideas will be poured into the system. So I request all of you to be alert to the new stimuli. And number 2, regarding as Sir was saying, even Mr. Das was saying, all of you are very anxious about minor nuances of law so far as cyber forensics are concerned, or for that matter, electronic evidence are concerned. These are all topics which are though under the purview of these acts, but very separate topics. We have course modules on that. We will be, in discussion with the authorities concerned, how the prosecutors of the state will be given training basically on electronic evidence, or as Sir was telling, how the tools of forensic science can be utilized practically in the courts of law, as you are the people who are the forerunners in the race of the justice. How you can use them, definitely those will be matters of discussion some other day. Though for this training, this capacity building training was actually intended As I was discussing with some of the prosecutors, I found when this is my 6th training, right? I am attending the 6th training in series. There were trainings for judicial officers, there were training for our new probationers. Now it's training for prosecutors. On 23rd, we are going to organize another program in collaboration with CDTI for the advocates who are your opponents in the court. So in all these trainings, one thing I just came across, that if I am given the assignment of reading the 3 laws, I couldn't do more. This is actually better. Listening to experts who are come prepared with their presentations. They have thankfully left their presentations. I have all of your emails. I will take the pain to share the data, whatever presentation is available, to all of you over email, so that you can utilize it as a reference later on. So please go on reading. Please go on reading. Please go on finding out the avenues where there is a scope of development, scope of interpretation, or there is a probable doubt or ambiguity. That will help you in the day-to-day court work. But I must say that these 2 days have been very intriguing. I was keenly listening to all the resource persons. They were wonderful in their respective capacities, though we may feel some resource person as better than the other. But to me in person, all the 3 resource persons were wonderful. We got the best of the collaboration and cooperation from CDTI. So before I conclude, let me formally propose a vote of thanks. Let me tell you that these set of programs, these are actually devised, designed, and these are conceptualized by none other than our own Honorable the CJI, the Chief Justice of India, who requested all the high courts and the judicial academies to conduct capacity building training programs for not only for judicial officers but also for prosecutors and advocates, because we acknowledge the fact that we as a team, we can do wonders in the field of justice delivery. So I am thankful to the Honorable Supreme Court and the Honorable CJI. At the same time, I am also greatly thankful to our Honorable Chief Justice, Honorable Mr. Justice Chakradhari Saran Singh, who is also the Patron-in-Chief of Odisha Judicial Academy, as he quickly agreed and took all the measures necessary for designing the training programs. I am also thankful to my Honorable Judicial Academy and Training Committee, Honorable Chairman, Mr. Justice Debabrata Das Sir, Honorable Judge, High Court of Orissa, and all the honorable members of the Judicial Academy and Training Committee. They helped us, they cooperated with us, they designed it, and they even fast forwarded the things. Within short span of time, we could be able to design and implement the training programs. I am really thankful. Next, I will give a special thanks to BPRD, Ministry of Home Affairs, Government of India, the CAPT, Bhopal, and of course, CDTI Kolkata. They have become our training partners. This new venture between us will go further, and it will manifest in many other successful training programs. Sir, I personally thank you and all your office bearers who are here, your directors, sir, because you have taken the pain for organizing the entire training program. I'm really thankful to you. Sir, I'm also thankful to all the 3 resource persons, Dr. Sarfaraz Ahmed Khan, Dr. Kavita Singh from NUJS West Bengal, and Dr. P. Paul Ramesh, Assistant Director CFSL, who is very much present here. Sir, we are thankful to you that you have taken the pain of elaborating various aspects of law to our prosecutors. And I am also thankful to DPP sir. Let us not forget his role in nominating all of you in a short span of time. I acknowledge what Mr. Das said, that it should have been given, information should have been given much earlier, so that you could have come prepared at least with your doubts and questions. So because this program is starting new, within a short span of time, we are organizing these programs. In future, whenever these kind of programs will be organized, we'll take care of this. I'm also thankful to all the prosecutors who are here, all the 30 prosecutors of our state. You have been wonderful audiences. My special thank to each one of you. I'm also thankful to all the prosecutors who have joined us through virtual mode. Till yesterday, I was under this hope that each one is at least participating. But today I came to know that yes, not only they are participating, they are also raising their concerns, raising their doubts. And I'm really thankful to all of you that you participated in the program, it despite being holiday, vacation period for all of you. Thank you very much, all of you. And a special thank goes to my officers, my team, the support staff. You must be seeing that the entire setup of the CPC of the High Court is here controlling the proceedings, the virtual VC proceedings. We have our training channel partners. They have provided all the best possible facilities for live streaming and video conferencing here. We have our resource in various fields, in electronics field, in our catering, our housekeeping. Everyone have given their part in successfully organizing this program. And so far as the takeaway is concerned, I have a positive frame of mind. I always see things in a positive manner. I am really hopeful, and not only hopeful, I am confident that the person you were 2 days back, you are not the same person today, right? So everyone must have taken some positive takeaway from this program. Please build upon it. It is just an foundation of an infrastructure. Please build upon it. If you have got any doubt, you are most welcome to write to us so that we can get the clarifications from the resource persons who attended these programs. If any resource person has left any doubt in your mind, please share that with us so that we can share it with CDTI and they can get clarifications from the resource persons. But please build upon it. So with these words, once again, I thank all of you, the resource persons, the collaborators, the office bearers, and all the audience who have joined us online. Thank you very much. With this, I declare this function as closed. Have a great day.